We are on the record for the hearings and the matters listed in the North Dakota Industrial Commission hearing docket for May 29th. I am David Garner, hearing examiner for these hearings. We're at the hearing room for the Department of Mineral Resources, Oil and Gas Division, and it is 9:02. On the docket, the following matters will be continued or dismissed. Case number 30803, dismissed. Case number 30797, continued to June hearings. Case number 30822, dismissed. The administrative docket starts on page 4 with case number 30822 and goes through case number 30910. These cases will be heard in the next room with Michael Zisch. Audio recordings of the cases in the administrative docket will be placed on the Oil and Gas website by the end of the week. If you wish to appear in one of the matters in the administrative docket, please appear in the next room. If there is opposition to the matter, it will be brought back into this hearing room to be heard, and your statements and evidence will be taken. We'll begin with moving to case number 30881. Application of Hesbachen Investments 2 LLC for an order amending the applicable orders for the Ellsworth, Bach, and Poole, McKenzie County, North Dakota to 1. Establish an overlapping stand-up 1920-acre spacing unit described as sections 5, 8, and 17, Township 149 North, Range 100 West, and authorize 3 horizontal wells to be drilled on such unit. 2, establish an overlapping 38, 40-acre spacing unit described as sections 5, 6, 7, 8, 17, and 18, Township 149 North, Range 100 West, and authorize 1 horizontal well to be drilled on such unit, and 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Hesbachen Investments 2 LLC. I have 3 witnesses appearing telephonically: John DeWitt, Jacob Smith, and Carson Noble, and all 3 should be on the line right now.
Mr. DeWitt.
Yes, sir.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
John, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Yes, my name is John DeWitt. I'm employed by Hess Corporation as a senior land negotiator with a business address of 1501 McKinney Street, Houston, Texas, 77010.
And John, have you previously testified before the commission?
Yes, I have.
Have you had your qualifications received as that of an expert?
Yes, I have.
And are you familiar with the land matters that are associated with these proposed spacing units?
I am.
I'd move the testimony of Mr. DeWitt be received as that of an expert.
Motion granted.
John, let's start with exhibit number 1. Can I have you identify the proposed spacing units we'll be discussing?
Yes, Exhibit 1 is the location map depicting Township 149 North, Range 100 West in McKenzie County. The blue outlines represent the 4 existing 1280 stand-up DSUs, sections 5 and 8, 6 and 7, 17 and 20, 18 and 19. The yellow outline represents the requested overlapping stand-up 1920 DSU, being sections 5, 8, and 17, and the green dashed outline represents the requested 3840 DSU, being sections 5, 6, 7, 8, 17, and 18.
Okay, let's move on to exhibit number 2. Can I have you take us through your working interest in the proposed 1920?
Yes, Exhibit 2 is the land plat of the proposed 1920 spacing request shown in the black dashed outline. Shown in green is the Hess-operated BW Ethel Larson DSU, where Hess's working interest is 76.68%, and the remaining owners with 23.32%. Shown in yellow is the Hess-operated BW Larson DSU, where Hess's working interest is 89.25%, and the remaining owners with 10.75%. The combined working interest of the proposed BW Barbara Ann 149-100 1705 spacing unit will be Hess with 80.87% and the remaining owners with 19.13%. That's all.
Okay, and exhibit number 3, can you take us through your working interest in that proposed 3840?
Yes, Exhibit 3 is the land plat of the proposed 3840 spacing request shown in the black dash outline. Shown in green is the Hess-operated BW Ethel Larson DSU, where Hess's working interest is 76.68 and the remaining owners with 23.32. Shown in blue is the Hess-operated BW KKMP DSU, where Hess's working interest is 78.78% working interest and the remaining owners with 21.22%. Shown in yellow is the Hess-operated BW Larson DSU, where Hess's interest is 89.25%, and the remaining owners with 10.75%. Shown in orange is the Hess-operated BW ABM DSU, where Hess's working interest is 80.05%, and the remaining owners with 19.95%. The combined working interest of the proposed BW Barbara Ann LW 149-100 1705 spacing unit will be Hess with 80.04% and the remaining owners with 19.96%. Finally, I'd like to mention that the spacing request is tied to previous spacing request case numbers 30805 and 30806 as shown on Exhibit 9. That's all I have. Thank you.
Okay, I have no further questions for Mr. DeWitt. I'd offer the land exhibits 1 through 3.
The exhibits are admitted. Any questions from the staff?
John, sections 5, 6, 7, and 8 are currently at lease line 2560. I assume you want that terminated?
Yes, we want that terminated.
Okay, thank you.
Mr. Smith,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, sir.
Jacob, can I have you state your name, tell us by whom you're employed and in what capacity, and give us your business address?
My name is Jacob Smith, employed by Hess Corporation as a geologist with a business address of 1501 McKinney Street, Houston, Texas, 77010.
And Jacob, have you previously testified before the commission?
Yes,
Have you had your qualifications received as that of an expert?
sir.
Are you familiar with the geology underlying the proposed spacing units?
Yes, sir.
I'd move the testimony of Mr. Smith be received as that of an expert.
Motion granted.
And Jacob, let's look at your exhibit number 4. Can you describe the structure underlying the proposed spacing units?
This is a middle Bakken structure map with a contour interval of 50 feet. Showing formation is dipping to the east. The blue rectangles are the existing DSUs. The gold is requested 1920. Green dash is requested 3840. And the purple cross-section is for the next exhibit.
Okay. Let's go ahead and take a look at that cross-section, your exhibit number 5. Can you walk us through that?
Yes, sir. This is a stratigraphic cross-section from the previous exhibit, flattened on the top of the Upper Bakken Shale, showing our target formations are present and continuous throughout the region.
Okay. I have no further questions for Mr. Smith. I'd offer the geology exhibits 4 and 5.
The exhibits are admitted. Any questions from the staff? Mr. Noble,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes.
Carson, can I have you state your name and tell us by whom you're employed in what capacity, and give us your business address?
Yes, name is Carson Noble, employed by Hess Corporation as a reservoir engineer. Business address of 1501 McKinney Street, Houston, Texas, 77010.
And Carson, have you previously testified before the commission?
Yes.
Have you had your qualifications received as that of an expert?
Yes, I have.
And are you familiar with the engineering matters associated with these proposed spacing units?
Yes.
Okay, I'd move the testimony, Mr. Noble, be received as that of an expert.
Motion granted.
And Carson, let's start with exhibit number 6. Can you describe for us how you would plan to develop the 1920?
Yes, so this shows the proposed 1920 development for sections 5, 8, and 17. Those dashed green lines show the proposed 3-mile development plan from the pad location denoted in blue.
Then moving on to exhibit number 7, how would you develop the 3840?
Yeah, so the 3840 for sections 5, 6, 7, 8, 17, and 18, the highlighted dashed green line is the proposed 3-mile lease line well over there on the west side.
Okay. Let's move on to the reservoir data and the economics for the spacing units and proposed wells.
Yeah, so this exhibit shows the reservoir and economic summary for a single Middle Bakken, a 3-mile Middle Bakken well in the Buffalo area. The expected EOR for this well is about 773,000 stock tank barrels, with roughly a 4.4% recovery factor. The econs will run at a $62 per barrel WTI pricing flat and work 100% working interest. Expected NPV is roughly $7.7 million, with a rate of return of about 51%.
And then moving on to exhibit number 5, as John indicated, these cases are sort of companions to some cases from last month. Can you kind of walk us through what the sort of full development in the area would look like?
Yep, so this is the zoomed out version of the base map, kind of denoting the various spacing cases from both this month and the prior month. Proposed spacing lease line wells are highlighted in yellow, kind of on the edges of the proposed 1920s.
Okay. And Carson, in your opinion, if the commission were to approve the 1920 and this 3840 to allow for that lease line well, would that prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
Yes, it would.
Okay. I have no further questions. I'd offer the engineering exhibits 6 through 9, as well as the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff? That concludes our hearing for case number 30881. Oh, I'm sorry. Come on up.
So I actually have a printout here of, is that actually, you guys just want to hand it down? So,
Well, hold on, hang 1 second. Let's get your name on the record.
so I'm Mark Meyer. I'm actually here
And
advocating.
let's get you sworn in, too.
Okay.
Please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes. So again, I'm Mark Meyer. I'm here. Basically, I'm a landowner that's been affected by a bunch of HES policies, and also I'm here advocating on behalf of my in-laws. So the bottom line here is I've been working for many years to try to get HES to reclaim a bunch of abandoned wells near my in-laws' place. And it started back in 2017. There was a significant number of abandoned wells, and here we are in 2024, and this piece of paper I passed around to you still have 8 abandoned wells that are within a mile of my in-laws' house, and some of those abandoned wells have been abandoned for on the order of 10 years without reclamation. So, I think it's pretty clear that that's in violation of North Dakota statutes on the reclamation side of the world. So I'm here actually because, you really can't get anywhere by emailing or talking to people on the phone. So I feel like the only way to do is show up to a public meeting like this and air it out a little bit. The Oil and Gas Commission has the authority to make this right, to penalize the companies that violate these laws. You can force the compliance on this. Not only that, I think you guys have the responsibility to make that happen. I think you have the authority and the responsibility, and you should do that. So I'm here to ask you guys to exercise that authority. Basically, that's why I'm here. So, and just so everybody, so we're all on the same page. I did a little bit of digging through relevant North Dakota statutes on this thing. So we put it all on record here. So I think it's NDCC 3808-04. So that's basically you have, the commission has the jurisdiction and authority over all of oil and gas production, right? NDCC 3808-04-12. So this is the statute that defines reclamation of land disturbed by oil and gas activity. So basically, any land disturbed by construction of well sites, such things, ultimately it has to be reclaimed properly, back to as close to its original state as possible, right? And then finally, NDCC 3808-16. So it turns out that the Oil and Gas Commission has the right to penalize, provide civil penalties against people or companies who violate those statutes. So, and then I think the very last one is NDCC 430203-34.1. Within a reasonable time, but not more than 1 year after a well is plugged, or if a permit expires or has been canceled or revoked, or a treating plant or saltwater handling facility is decommissioned, you basically have to have it reclaimed within 1 year. So we can flip to the handout that I gave you guys. So this is a picture of 4 square miles in Pleasant Valley Township, Williams County, North Dakota, sections 19, 20, 29, and 30. And you'll see a number of green blocks on that, and each one of those is an abandoned well. And the little blue block on that is my in-laws' place. So they're pretty much surrounded by abandoned wells, in addition to working wells. So if you flip to the case number table, I actually dug through a little bit of your guys' own website to look at this stuff. And so 13504, that's case number, is the well site that my father-in-law has actually been trying to get reclaimed. That actually had its last production in December of 2014. So I think 2 years, we'll call it a year before your permit expires, and then you have a year after that to actually get the land reclaimed. So I would say that probably, the expected reclamation date on that location should have been December of 2016. So we'll give you to the summer, maybe, summer of 2017. The thing didn't even get plugged until 2018, and here we are in the middle of 2024, and it still has not been reclaimed. So you can work your way down the list. There's 5 wells that were in that same area that plugged in that same time frame, abandoned in that same time frame, that still have yet to be reclaimed. One of the practically original well, case number 254, stopped producing in 1994. If you go back to that picture on the previous page, turns out that's right next to my in-laws' homestead. It's the closest one to it. It's been sitting there, that location has been sitting there for, I don't know, what is that, 30 years, I guess? So, anyway, that's kind of the problem. And if you were to, I only looked in 4 square miles in Pleasant Valley. So think about extrapolating that problem to a little bit bigger area. So one of the, when I've talked to people, I've emailed people, I've done all kinds of stuff trying to get this thing resolved. And so this is why I'm actually here today, because that apparently is ineffective. So one of the things that people have told me when I've spoke to various Oil and Gas Commission people is the lack of equipment and labor resources is a major limiting factor in these reclamation timelines. So one thing I'll say in that same 4 square miles that we're talking about here, since those wells have been abandoned, 10 new wells have been developed by Hess in that same area. So the really great thing about this is based on the way you currently regulate this thing, there's no economic impact to Hess for non-compliance with the reclamation timelines. It's just simply, they just get to do it, and the landowners get to suffer for it. So, I will say that not reclaiming the land in a timely manner actually is an economic impact to the landowners as well, right? I mean, you got multiple acres of land tied up in a location. You got, I mean, the banded locations are basically noxious weed patches. You end up with, all kinds of great stuff coming out of there.
Mr. Examiner, I understand this is public comment, but I'm going to object. I mean, none of this is related in
100%
any way,
related.
shape, or form to the spacing of the 1920 and the 3840. I mean, Hess hasn't been made aware of this. We'll look at this and, more than willing to communicate with Mr. Meyer, but this really isn't the appropriate forum or venue for, raising these complaints in this spacing case. It's all entirely unrelated to the spacing.
So
I will note your objection, but I'm going to allow him to make his piece.
because I would say granting other relief is maybe appropriate as part of your case is very, very appropriate here. My other real complaint here is why do I have to be here to actually get compliance on this? There's no reason that I should have to actually make this trip and get in front of the public to try to get Hess to actually comply with this. So, if you can tell, I would say I'm somewhere between disappointed and angry about this, because I actually owned land also in Pleasant Valley, and it took me 5 years of badgering Hess to get them to actually reclaim a well on that property, so. So, I guess I have some very specific requests here. So what I've been told is the real problem with meeting reclamation timelines is there's no manpower or equipment for that. So, instead of building new locations and drilling new wells, why don't you redirect the manpower and equipment to actually reclaim the wells that are already out there? So defer this approval. That's one of the things I'm asking you for. And then you have the power to assess civil penalties on Hess to force the compliance. Make it actually an economic impact on Hess. So, I mean, this is, again, you have 8 wells in 4 square miles. So I don't know how many acres Hess has under production, but it's probably a lot more than 4 square miles. So you can extrapolate that out. And then the last thing I would ask you guys to do is go through and assess what the reclamation timelines are on all the wells that have been abandoned in North Dakota and get those fixed. So it looks like a little bit of an industrial disaster around where my in-laws live. So anyway, thank you.
Attorney Mann, I'll give you a chance to respond.
Yeah, I just renew my objection. I think the testimony should be stricken. It's not related to the spacing of these wells. Nothing's been presented in any way, shape, or form with respect to whether or not the proposed 1920 acre spacing unit should be granted or the 3840. I mean, we'll look at any of this information, but I'd object to the exhibit being admitted into the record as well. Again, entirely unrelated to the spacing of these wells. So that's it.
And like I said, your objection is noted, but I'm going to allow the testimony to stand.
Thank you.
Did you want to admit your exhibit?
Yes, please.
Okay. The exhibit will be admitted. Any questions from the staff?
Mark, on your front page of your exhibit, these green blocks with the numbers in them, you refer to them as case numbers on the back. Are these the file numbers of the well?
That's the file numbers of the wells. It's basically off your guys' own websites.
And the blue block,
You can see that L-shaped tree set up there.
Yeah.
That's my mother-in-law's farm.
so it's directly to the left of it.
Yeah.
And all these wells in green that you noted, is this on land that you or your in-laws own?
Nope. But it's I thought about that before I came here. It's actually, I think, in the interest of all the citizens of the state of North Dakota to actually have this stuff properly reclaimed. It's not just the landowners themselves.
So are any of these green squares on land you or your in-laws own?
Yes, 13504 is actually
Is the one?
is the one that's, and that's actually particularly onerous because it's got about a half a mile road right down the middle of the field that, you have to have driven around with giant machinery for the last 10 years.
And if you know, does your father-in-law, do they get a rental payment for that site being there?
I think none of those wells get rental payments because that was prior to the change in North Dakota policy for rental payments. So I think there's absolutely no impact. My assessment is there's no economic impact for
So-
leaving those wells hanging there.
So on 13504, your father-in-law doesn't get rental payments, or you don't know if he gets rental?
He does not get rental payments for that.
Okay, thank you.
Anything else?
Thank you.
That concludes our hearing for case number 30881. 30882, application of Hesbachen Investments 2 LLC for an order amending the applicable orders for the Manitou Bakken Pool to establish an overlapping 2560 acre spacing unit described as sections 3, 4, 9, and 10, Township 155 North, Range 94 West, Montreal County, North Dakota, and authorize one horizontal well to be drilled on such unit or granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Hesbachen Investments 2 LLC. I'll have three witnesses appearing in this case. It'll be John DeWitt again, and then Othman El Halou and Aisha Keshimir.
And just a reminder to Mr. DeWitt, he's still under oath.
Okay. John, let's start with your exhibit number 1. Can you describe the proposed spacing unit?
Yes, Exhibit 1 is the location map, the 15 Township 155 North, Range 94 West in Montreal County. The blue outlines represent the 3 existing DSUs made up of Sections 3 and 10, Section 4, and Sections 9, 16, and 21. The green outline represents the requested overlapping 2560 DSU, being Sections 3, 4, 9, and 10.
Okay. And moving on to exhibit number 2, can you take us through your working interest in that proposed spacing unit?
Yes, Exhibit 2 is the land plat of the proposed 2560 spacing request, shown in the black dashed outline. Shown in blue is the Hess-operated Ian Rice A DSU, where Hess's working interest is 93.26% and the remaining owners with 6.74%. Shown in orange is the Missouri River Royalty Corp. operated Manitou 4-1H DSU, where the Missouri River Royalty Corp's working interest is 90.83%, Hess's working interest is 8.97%, and the remaining owners with 0.2%. Shown in yellow is the Hess-operated Ian Dakota DSU, where Hess's working interest is 88.92%, and the remaining owners with 11.08%. The combined working interest of the proposed Ian North Dakota LE 155-94-0409 spacing unit will be Hess with 71.11% and the remaining owners with 28.89%. Up to Missouri River Royalty Corp. about their plans with the Manitou 4-1H, and their plan is to continue producing unless something material changes. Otherwise, there was no objection to our proposed spacing request. And finally, I'd like to mention again that the southern portion of the Ian Dakota DSU will be spaced in case number 30883, which will be heard next. That's all I have. Thank you.
Okay. That's all the questions I have for Mr. DeWitt. I'd offer the land exhibits 1 and 2.
Exhibits are admitted. Any questions from the staff? Ms. El Halou.
Mr.
I'm sorry, Mr.
Yes, sir.
El Halou. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I swear.
Othman, can I have you state your name and then tell us by whom you're employed in what capacity and give us your business address?
Sure. My name is Othman Al-Halou. I'm employed by Hess Corporation as an operations geologist with the business address of 1501 McKinney Street, Houston, Texas, 77010.
And Othman, have you previously testified before the commission?
I have.
Have you had your qualifications received as that of an expert?
They were.
And are you familiar with the geology underlying the proposed spacing units?
I am.
Okay, I'd move the testimony of Mr. Al-Halou be received as that of an expert.
Motion granted.
And Othman, let's take a look at exhibit number 3, if you can describe for us the structure underlying the proposed spacing unit.
Sure. Exhibit 3 shows the location of the existing DSUs in blue and the requested 2560 DSU outline in green with the existing wells marked. The top middle Bakken structure map is presented with a 50-foot contour interval showing that the formation is dipping to the south. The line A to A prime represents the location of the wells that are used in the cross-section in the next exhibit.
Okay, and let's move on to that exhibit 4. Can you walk us through that cross-section?
Sure. Exhibit 4 is a stratigraphic cross-section that's flattened on the top of the Bakken, showing that the targeted formations are present and continuous throughout the region.
I have no further questions for Mr. Al-Halou. I'd offer exhibits 3 and 4.
Exhibits are admitted. Any questions from the staff?
Hoffman, the wells on your Exhibit 4, the gamma traces that you're displaying, are those on measured depth?
Yeah, they are. The thickness is the same. The scale is different between the wells.
Okay, but,
The thickness is same.
yeah, so the thickness you're seeing on the lower Bakken shale isn't the true vertical thickness, it's the thickness of the well as it was drilling through it via measured depth?
Correct. Correct.
Okay, thank you.
Ms. Ketchmere,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do.
Aisha, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Sure. My name is Aisha Kashmir, reservoir engineer employed by Hess Corporation. Business address is 1501 McKinney Street, Houston, Texas 77010.
And Aisha, have you previously testified before the commission?
Yes, I have.
Have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the engineering matters associated with proposed spacing units?
Yes, I am.
Okay, I'd move the testimony of Ms. Keshmir be received as that of an expert.
Motion granted.
And Aisha, let's look at exhibit number 5. Can you describe for us how you would develop the spacing unit?
Sure. Exhibit 5 shows the proposed 2560 development plan for Section 3, 4, and Section 9 and 10. The bold dashed line is the proposed well and will be drilled in the middle of Bakken formation.
Okay, let's move on to the reservoir data and economics, exhibit number 6.
Sure. Exhibit 6 shows the reservoir and economic summary for a single 2-mile lateral middle Bakken well in East Nesson area. The expected EUR is around 900,000 stacked barrels. Economic will run at $62 WTI flat and 100% working interest. The expected MPV is around 10 million with over 100% rate of return.
Okay. And Aisha, in your opinion, would establishment of the 2560 allow for that lease line well, would that prevent waste and protect relative rights?
Yes.
Okay, I have no further questions for Ms. Keshmir. I'd offer exhibits 5, 6, and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Aisha, excuse me, on your Exhibit 5, are you going to locate this well somewhat Or how far east of the, west of the section line?
Be around 100 feet.
Okay, thank you.
That concludes our hearing for case number 30882. Case number 30883. Application of Hesbakken Investments 2 LLC for an order amending the applicable orders for the Manitou Bakken and/or Alkali Creek Bakken Pool, Montreal County, North Dakota, to 1, establish an overlapping stand-up 1280-acre spacing unit described as sections 16 and 21, Township 155 North, Range 94 West, and authorize 4 horizontal wells to be drilled on such unit. 2, establish 2 overlapping 2560-acre spacing units described as sections 15, 16, 21, and 22, and sections 16, 17, 20, and 21, Township 155 North, Range 94 West, and authorize 1 horizontal well to be drilled on each such unit. And 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing on behalf of Hesbakken Investments 2 LLC. And Mr. Examiner, I have the same 3 witnesses in this case.
And just a reminder, they're still under oath.
Okay. And John, let's go ahead and start with exhibit number 1. If I could have you identify the proposed spacing units.
Yes, Exhibit 1 is the location map depicting Township 155 North, Range 94 West in Montreal County. The blue outlines represent the 3 existing DSUs made up of sections 17 and 20, 9, 16, and 21, and sections 15, 22, 27, and 34. The yellow outline represents the requested overlapping stand-up 1280, DSU being sections 16 and 21, and the green dashed outline represent the 2 requested overlapping 2560 DSUs, being sections 15, 16, 21, and 22, and sections 16, 17, 20, and 21.
And John, just for context again, I believe last month there was case 30719, and in that case you'd requested 4 and 9 be a 1280, and then also 4, 5, 8, and 9 as a 2560. Is that correct?
That is correct.
Okay. Let's move on to exhibit number 2 then. If you can walk us through your working interest in the 16 and 21 1280.
Yes, Exhibit 2 is the land plat of the proposed 1280 spacing request, shown in black dash outline. Shown in blue is the Hess-operated Ian Dakota 15594-211609. DSU, where Hess's working interest is 88.92%, and the remaining owners with 11.08%. The combined working interest of the proposed Ian South Dakota 15594-2116 spacing unit will be Hess with 91.31%, and the remaining owners with 8.69%.
Okay, and let's go on to exhibit number 3. If you can take us through the working interest in that 2560.
Exhibit 3 is the land plat of the proposed 2560 spacing request, shown in the black dash outline. Shown in blue is the Hess-operated Ian Dakota 15594-211609 DSU, where Hess's working interest is 88.92%, and the remaining owners with 11.08%. Shown in green is the Hess-operated Ian Johnson DSU, where Hess's working interest is 76.71%, and the remaining owners with 23.29%. The combined working interest of the proposed Ian South Dakota LW 15594-2116 spacing unit will be Hess with 82.82%, and the remaining owners with 17.18%.
Okay, and then on to exhibit number 4 and the other 2560.
Yes, Exhibit 4 is the land plat of proposed 2560 spacing request, shown in black dash outline. Shown in blue is the Hess-operated Ian Dakota 15594-211609 DSU, where Hess's working interest is 88.92%, and the remaining owners with 11.08%. Shown in yellow is the Hess-operated Ian Jeffrey A DSU, where Hess's working interest is 68.94%, and the remaining owners with 31.06%. The combined working interest of the proposed Ian South Dakota LE 15594-2115 spacing unit will be Hess with 78.93%, and the remaining owners with 21.07%. That's all I have. Thank you.
Okay, I have no further questions for Mr. DeWitt. I'd offer exhibits 1 through 4.
The exhibits are admitted. Any questions from the staff? You can proceed.
All right, Othman, let's take a look at exhibit number 5, if you can describe the structure underlying the proposed spacing units.
Sure. Exhibit 5 shows the location of the existing DSU in blue and the requested 1280 DSU and 2560 DSU in gold and green, respectively, with the existing wells marked. The top middle Bakken structure map is presented with a 50-foot contour intervals showing that the formation is dipping to the south. The line A to A prime represents the location of the wells used in the cross-section in the next exhibit.
Okay. And if you can take us through that cross-section, exhibit number 6.
Sure. This is same cross-section showing that the Middle Bakken is present and continues throughout the region.
Okay, I have no further questions for Mr. El Holu. I'd offer exhibits 5 and 6.
The exhibits are admitted. Any questions from the staff?
Alfman, again, just confirming the, on the cross-section, the gamma you have is measured depth gamma, not TVD gamma?
Correct. Yep. Measured up. Yep.
Okay, thank you.
Thanks.
You can proceed.
All right, Aisha, let's look at exhibit number 7, and if you can describe for us how you developed the 1280.
Sure. Exhibit 7 shows the proposed 1280 development plan for section 16 and 21. The dashed lines are the proposed wells and will be drilled in the Middle Bakken and Three Forks formation.
Okay. And then exhibit number 8, how would you develop that 2560?
Exhibit 8 shows the proposed 2560 development plan for section 1516 and section 2122. The bold dashed line is the proposed well and will be drilled in the Three Forks formation.
Okay. And then moving on to exhibit number 9 and the other 2560, how would you develop that?
Yeah, Exhibit 9 shows the proposed 2560 for section 1617 and 2021. The same thing, the bold dashed line is the proposed wells and will be drilled in the Three Forks formation as well.
Okay. Then exhibit number 10, is that just kind of full development plan?
Correct. This is just a full development plan that shows how we will be developing those sections 16 and 21 and 4 with the lease line.
Okay. Let's move on to exhibit number 11. Can you describe for us the reservoir data and then what the economics look like? For the Middle Bakken well, I
Sure.
guess, first. Wells.
Correct. Exhibit 11 shows the reservoir and economic summary for a single 2-mile Middle Bakken well in East Nesson area. The expected EUR is around 900,000 stock tank barrels. The economics were run at 62 WTI flat and 100% working interest. The expected NPV is around 10 million with 100% rate of return, over 100% rate of return.
Okay. And then moving on to exhibit number 12, take us through reservoir data and economics for the Three Forks wells.
Sure. For Exhibit 12 is showing the 2-mile Three Forks well in East Nesson area. The expected EUR is around 740,000 stock barrels. Economics were run at 62 WTI flat and 100% as well working interest. The expected MPV is around 7.4 million with 87% rate of return.
Okay. And Aisha, in your opinion, would establishment of these spacing units prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
Correct, yes.
I have no further questions. I'd offer exhibits 7 through 12 in the gas capture plan affidavit.
The exhibits are admitted. Any questions from the staff?
Aisha, on your exhibit 10, what is your plan for the existing wells?
The existing wells will be secured, and unless it's a major thing that happens to them, but more like we will keep producing those existing wells.
And are you going to drill all 6 wells shown here at the same time?
It's going to be around 2 batches, so we will drill 3 first, then we come back and drill the other 3. And there is possibility we can drill them all 6 at the same time. It will depend on capacity.
Would you be drilling that western or eastern pad first?
We will be doing the western pad first.
And what's your timeline for spudding that pad?
It's October 2026.
And then how long would you evaluate before drilling the eastern pad?
And the eastern pad right now it's around November 2027 pad, so it's around 1 year between the 2 batches.
And for the 2 Three Forks section line wells, how far would those be drilled off the section line?
Those going to be right on the section line.
For both of them?
Both of them, yes. Correct. Yes, sir.
Thank you.
Aisha, looking at your exhibits 11 and 12, the reservoir data you have presented there, is that supposed to be a representative of both the Middle Bakken and Three Forks combined? I'm assuming you don't have 115 feet of Middle Bakken or Three Forks.
Yeah, it's combined. It's significant for both Middle Bakken and Three Forks.
Okay, thank you.
Aisha, we've seen a lot of recent cases by Hess, among others, where they're only drilling in the Middle Bakken. What's the interest in I assume it's the first bench of the Three Forks here?
Yes, it's the first bench, and this is East Nesson, what we call East Nesson South. It's actually like in Township 155, where the Three Forks is thicker compared to when we go northern part of East Nesson, which means like as you go to 156, Township 156, 157, the Three Forks formation start to get thinner and thinner. So we have data we drilled before Three Forks in this area that shows that the Three Forks is as good as the Middle Bakken in Township 154 and 155.
Okay, thank you.
Aisha, this is Lynn Helms. Looking at, probably Exhibit 1 shows it the best. What is Hess's plans for further development in Section 9, which is part of the existing spacing unit?
Yes, so that was part of the spacing request. This is John DeWitt. That's part of the spacing request that we submitted last month.
Okay.
4 and 9 as a 1280 as well.
4 and 9?
Yep.
Thank you.
That concludes our hearing for case number 30883. Case number 30884. Application of Hessbakken Investments 2 LLC for an order amending the applicable orders for the Antelope Creek and/or Sather Lake Bakken Pools, McKenzie County, North Dakota, to 1, establish an overlapping laydown 1920-acre spacing unit described as sections 21, 22, and 23, Township 149 North, Range 101 West, and authorize 4 horizontal wells to be drilled on such unit. 2, establish 2 overlapping 38, 40-acre spacing units described as sections 14, 15, 16, 21, 22, and 23, and sections 21, 22, 23, 26, 27, and 28, Township 149 North, Range 101 West, and authorize 1 horizontal well to be drilled on each such unit. And 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Hessbakken Investments 2 LLC. Mr. Examiner, we're going back to the same 3 witnesses from the first case now, so it'll be John DeWitt, Jacob Smith, and Carson Noble.
And they're still under oath.
Okay. And John, let's go ahead and start with exhibit number 1, if you can identify the proposed spacing units for us.
Yes, and please bear with me. There's a lot of reading coming up on the next 4 exhibit. Exhibit 1 is the location map depicting Township 149 North, Range 100 West in McKenzie County. The blue outlines represent the 6 existing 1280 stand-up DSUs, Sections 14 and 23, 15 and 22, 16 and 21, 26 and 35, 27 and 34, and 28 and 33. The yellow outline represents the requested overlapping laydown 1920 DSU, being sections 21, 22, and 23. The green dashed outlines represent the 2 requested overlapping 3840 DSUs, being sections 14, 15, 16, 21, 22, and 23, and sections 21, 22, 23, 26, 27, and 28.
Okay. And let's move on to exhibit number 2 then, if you can start with that one and take us through your working interest in the proposed 1920 laydown.
Yes, this is the land plat of proposed 1920 spacing request as shown in the black dashed outline. Shown in green is the Hess-operated B.W. Hagen DSU, where Hess's working interest is 87.08% and the remaining owners with 12.92%. Shown in blue is the Hess-operated B.W. Moran DSU, where Hess's working interest is 81.64% and the remaining owners with 18.63%. Shown in yellow is the Hess-operated B.W. Bell DSU, where Hess's working interest is 54.83% and the remaining owners with 45.17%. The combined working interest of the proposed B.W. Kenny H. South 3 Mile 149 101 2123 spacing unit will be Hess with 74.52% and the remaining owners with 25.48%.
And John, just before we move on, again for some context, last month Hess had requested that 14, 15, and 16 be established as a laydown 1920, is that correct?
That's correct.
Okay, and then I guess also a lease line well to the north of that on a 3840 was part of that request as well?
That's correct.
Let's move on then to exhibit number 3, if you can take us through your working interest in that proposed 3840.
Yes, Exhibit 3 is a land plat of the proposed 3840 spacing request as shown in the black dash outline. Shown in green is the Hess-operated B.W. Hagen DSU, where Hess's working interest is 87.08% and the remaining owners with 12.92%. Shown in blue is the Hess-operated B.W. Moran DSU, where Hess's working interest is 81.64 and the remaining owners with 18.63%. Shown in yellow is the Hess-operated B.W. Bell DSU, where Hess's working interest is 54.83 and the remaining owners with 45.17%. The combined working interest of the proposed B.W. Kenny H. South 3 Mile LN 149 101 2123 spacing unit will be Hess with 74.52% and the remaining owners with 25.48%.
And then finally, exhibit number 4, take us through your working interest in that proposed 3840.
Yes, Exhibit 4 is the land plat of the proposed 3840 spacing request shown in the black dash outline. Shown in green is the Hess-operated B.W. Hagen DSU, where Hess's working interest is 87.08% and the remaining owners with 12.92%. Shown in blue is the Hess-operated B.W. Moran DSU, where Hess's working interest is 81.64% and the remaining owners with 18.63%. Shown in yellow is the Hess-operated B.W. Bell DSU, where Hess's working interest is 54.83% and the remaining working interest owners with 45.17%. Shown in orange is the Iron Oil operated Antelope 4-33-28H DSU, where Iron Oil et al. Owns 100% of the working interest and Hess does not have any. Shown in purple is the Iron Oil operated Antelope 2-34-27H DSU, where Iron Oil et al. Owns 100% of the working interest and Hess does not own any working interest. Shown in gray is the Iron Oil operated Antelope 5-35-26H DSU, where Iron Oil et al. Owns 94.21% of the working interest and Hess owns the remaining 5.79%. The combined working interest of the proposed B.W. Kenny H. South 3 Mile LS 149, 101, 21, 23 spacing units will be Hess with 38.22, Iron Oil with 49.04%, and the remaining owners with 12.74%. Also to note that Hess formally notified Iron Oil of its intent to space and develop this DSU, and there were no objections. That's all I have. Thank you.
Okay. I have no further questions for Mr. DeWitt. I'd offer exhibits 1 through 4.
The exhibits are admitted. Any questions from the staff? You can proceed.
All right, Jacob, let's take a look at exhibit number 5. Can you describe the structure underlying the proposed spacing units?
This is a structure map on the Middle Bakken with contour interval of 50 feet, showing formation dipping to the east. And the purple A to A prime represents the wells used in the next section.
Okay. And let's move on to exhibit 6 then, that cross-section. Take us through that exhibit.
Yes, so this cross-section is flattened on top of the Upper Bakken Shale, showing the formations are present and continuous.
Okay. I have no further questions for Mr. Smith. I'd offer exhibits 5 and 6.
Exhibits are admitted. Any questions from the staff? You can proceed.
Carson, let's look at exhibit number 7 and take us through that exhibit. Describe how you developed the laydown 1920.
Yep, so this exhibit shows the proposed 1920 development for sections 21, 22, and 23. Dash green line shows the proposed 3-mile development plan for the pad locations denoted in blue. Expectations would be that we would drill from the west to the east on this pad.
Okay. And then moving on to exhibit number 8, how would you develop that 3840?
Yeah, so this is 3840 for sections 14, 15, 16, 21, 22, and 23. You can see the highlighted dash green line being the proposed 3-mile lease line well. Will be roughly right on the lease line for that well.
Okay. And then exhibit number 9, the other 3840 you're looking at developing.
Yep, similar story for this one for sections 21, 22, 23, 26, 27, and 28. You can see the highlighted dash green line to the south. That's that proposed 3-mile lease line well.
Okay.
It's going to be a hair above the southern lease line.
Okay. And let's move on to exhibit number 10 and go through the reservoir data and economics. Just before you do, Carson, we've got the label on that. What it references case 30802. Is the reservoir data and economics that you've got here, is that for this case?
That is for this case, but it'll be identical
Pretty
to the air case. Yeah, these are all in the same area. It's kind of a companion.
Sure. So
spacing
case 30802, and you'll show that I think on the map. That was that for the laydown directly to the north that you proposed last month.
Correct.
Okay. Yeah. Go ahead and walk through that reservoir data and economics then.
Yep, this is the reservoir economic summary for a single 3-mile Middle Bakken well in this Buffalo Wallow area. Expected EUR about 773,000 stock tank barrels, roughly a 4.4% recovery factor. Econs run at $62 for real WTI flat, 100% working interest. Expected NPV, roughly $7.7 million, with rate of return of 51%.
Okay. And then let's move on to exhibit number 11, kind of take us through the full development in that area that we're looking at.
Yes, this is the zoomed out version of the base map denoting the spacing cases, the companion spacing cases from both this month and the prior month. You can see the lease line wells are all highlighted in yellow, kind of both northern and southern for each of these cases.
Sure. And Carson, in your opinion, if the commission were to approve this spacing for the development you've described, would that prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
Yes, it would.
Okay. I have no further questions for Mr. Noble. I'd offer exhibits 7 through 11 and the gas capture plan affidavit.
The exhibits are admitted. Any questions from the staff? That concludes our hearing for case number 30884. Case number 30803, application of Hesbachen Investments 2 LLC for an order amending the applicable orders for the Clear Creek, Camel Butte, and/or Blue Buttes Bakken pools to establish an overlapping 38-40 acre spacing unit described as sections 12, 13, and 24, Township 151 North, Range 96 West, and sections 7, 18, and 19, Township 151 North, Range 95 West, Mackenzie County, North Dakota, and authorize one horizontal well to be drilled on such unit or granting such other relief as may be appropriate. This case has been dismissed. That concludes our hearing for case number 30803, and with that, we'll take a 10-minute break. We are back on the record. It is 10:18. We resume with case number 30885. Application of Five States Operating Company LLC for an order amending the applicable orders for the Bull Creek Madison Pool to 1, to establish two 320-acre spacing units in the Bull Creek Madison Pool, consisting of the east and the west of Section 28, Township 138 North, Range 99 West, Stark County, North Dakota, and authorize one horizontal well to be drilled on each such unit. 2, to allow the wells to produce at a maximum efficient rate, or 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Five States Operating LLC. I have one witness in this case, Jeff Brem, and I believe he's on the line right now.
Mr. Brem?
Yes, can you hear me?
Yes. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do.
Jeff, can I have you state your name, tell us by whom you're employed and what capacity, and give us your business address?
Okay. My name is Jeffrey Brem. I am with Phoenix Energy Partners, consulting for Five States Operating. My business address is 4702 Gladesdale Park Lane, Katy, Texas.
And Jeff, have you previously testified before the commission?
I have, yes.
And have you had your qualifications received as that of an expert?
I have, yes.
And are you familiar with the proposed spacing that we're looking at today?
Yes, I am.
Okay, I'd move the testimony of Mr. Brem be received as that of an expert.
Motion granted.
And Jeff, let's look at exhibit number 1. And just last month, we were here before the commission, and you've got it noted here in that case 30808, and we'd requested to extend the field boundaries for Bull Creek Field and establish some spacing units, but the ones that you're looking at today, just, we didn't get those included, so you're here today to try to get those added, is that correct?
That's correct, yes.
Okay. So you just briefly kind of take us through that locator map exhibit.
Okay, that's Exhibit 1. And in the previous case 30808, you can see the extension, the requested extension, including sections 22, 23, 26, and 27 in Township 138 North, Range 99 West, that we requested on the 24th of April.
And let's move on then to exhibit number 2. Can you just describe for us what your working interest is in those proposed spacing units?
Yeah, the two spacing units that we are requesting are in section 28. And we have, in the west half, a working interest of 82%, and in the east half, a working interest of 100%.
And Jeff, let's move on to exhibit number 3, if you can describe the structure underlying those proposed spacing units.
Right. The this map is at the top of the Freiberg Gamma marker, which is fairly well known in the area, and it is a tine surface. And you can see that the structure is essentially dipping off to the north at a fairly regular contour spacing. And in section 28, which is kind of down towards the bottom of the map, you can see that also is the case down there.
Okay. Let's move on to the net pay map that you've got in exhibit number 4. Take us through that.
Okay. In this case, this is the total net pay thickness. This is using a porosity cutoff of 9% and a water saturation cutoff of 65%. And in section 28, again down towards the bottom of the map,
you can see that the net pay is approximately between 28 and 32 net feet.
And then you've got the cross-section identified that we're gonna look at next on that map as well?
That's right. That's the line in pink there
Okay.
between the Baudouin State and the Kabush State wells.
Yep. Let's move on then to the cross-section, if you can take us through that, Exhibit 5.
Okay. The reservoir target that we are going to be using in wells in this area is indicated by the arrow over on the right. Our zone designation, you can see there A, B, C, and D. So we're in the lower B zone. That corresponds, I believe, to sort of previous designations as being the upper Mohall. And we expect that the net pay distribution in Section 28 is going to look similar to that of the log on the left of the Baudouin State.
Okay. Let's move on to Exhibit 6 then. Take us through your proposed development plan.
Okay. In Section 28, we are going to be proposing to drill or to obtain a permit to drill a sort of a triple lateral. As you can see there, this well design is similar to the two others that you can see sort of in the upper left of the map, the Rocky Hill 1.8 and the Rocky Hill 1.16. We propose that eventually we will have these wells in each of the 320-acre spacing units that we have proposed, not only in Section 28, but also in other sections. You can see there 22, 23, 26, and 27, which we also asked for in case 30808.
Okay. Let's move on then to Exhibit number 7. Can you take us through the reservoir data and the economics?
Right. The net pay, which we are anticipating, is shown in the lower right. An average net pay thickness of about a little bit under 30 feet. Average porosity of 13.8%, and water saturation is calculated at 23.8%. Our expected results that we're anticipating for such a well are shown at left, with an initial rate of 300 barrels a day and an eventual abandonment rate at some time in the future of 10 barrels a day for an EUR of 467,000 barrels. The well cost, which we are estimating is $5.4 million, with a PV20 of $840,000, an ROI of 1.86x, internal rate of return of 15.4%, and a payout of approximately 4 years. And this is based on an oil price assumption of $70 flat, OPEX $25,000 a month, and saltwater disposal cost of 25 cents a barrel.
Okay. Jeff, in your opinion, if this spacing gets approved, would that prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
I believe so, yes.
Okay. I have no further questions. I'd offer Exhibits 1 through 7.
Exhibits are admitted. Any questions from the staff?
Jeff, starting, I guess, with your Exhibit 7 and your Exhibit 5, I just want to try to clarify a few things. On the left side of your Exhibit 5, you have identified the Mohall and the Mission Canyon and then Freiburg porosity zone.
That's right.
On the right side of that cross-section, you're labeling them all as Freiburg, and you're targeting what you have identified as the B zone within the Freiburg or Upper Mohall, depending on what you call it.
Correct, yep.
Okay. Jumping back to Exhibit 7, on the bottom right-hand corner there, you got the reservoir parameters. Your B zone values are just for the B zone, and your Freiburg zone would be for the whole thing you have identified as the Freiburg or Mohall on Exhibit 5, A, B, C, and D.
That's correct.
Okay.
And those numbers that you see for the total Freiburg zone are estimated from the net pay map.
Okay. And then, jumping back to Exhibit 4 real quick, the other trilateral wells, drilled a little bit to the north and west of this, are they all drilled in that same interval, or are they drilled in a different target?
They are drilled in the same interval,
Okay, so
the
they're
lower B zone.
lower B. Okay. Okay, thank you.
Jeff, do you have, is there gas infrastructure in this area?
There is not.
And part of your application requests to allow the wells to produce at a maximum efficient rate. Do you know what, you estimate the wells are gonna IP at 300 barrels a day?
That's correct.
And do you have production history in the area to show how their production declines?
Well, we have the results that we, since we started production in the Rocky Hill 1.8 and the 116, that show that the decline proceeds and then eventually levels off at approximately the sort of the maximum rate that is stipulated in the field rules of 100 barrels a day.
So currently in the Bull Creek Mazin Pool, it's what we refer to as the 60-60-60. Are these wells going to perform better than that, where you need relief from that?
It is possible. We are in an area down here where we have a thicker net pay, and we are anticipating thicker units that we would be producing from, so that is possible, yes. And we would at that time seek relief from those field rules.
Okay.
And Mark, if I may, in last month in that case, I think it was 30808, we provided some of that information in that case. In that case, we saw essentially the same kind of spacing and extending the field. So if it makes sense to kind of incorporate the record from that case into this one, if it would be helpful.
Sure. In that case, I don't recall, did we put anything into the record or take administrative notice of a previous case for the 440-foot setback?
We requested at that time, and we are requesting, I guess, here again in Exhibit 6, that we have the same setbacks that were established for the Rocky Hill field back in, I believe it was October of 2022, and were granted. And that is 440 feet for the spacing from the edge of the 320 to the outside laterals, and 400 feet on the north and south limits of the setback box. We would request that that same setback arrangement again.
Do you recall, Jeff, in that case, was there some evidence presented on justifying that setback relief?
Yes, we and again, put it back in I believe it was October of 2022. According to our calculations, because of the relatively low permeability of this reservoir, the drainage radii around the laterals is approximately at the end of life. The well is approximately that 440 feet, and 400 feet at the ends of the laterals in the north. And these are basically volumetric calculations which support this.
So do you recall what case number that was? If not, we can find it.
I don't recall the case number, no.
So Wade, I assume it would be appropriate to incorporate the record from the appropriate case for that justification?
Yes, yeah, absolutely.
Okay, thank you.
Jeff, I guess just one more question. Apologize if I missed it, but completion-wise, what do you plan to do for the completion on these laterals?
These would be open hole completions, no casing, no fracks, no acidization anticipated.
Okay, thank you.
Okay, so just to be clear, we're going to incorporate the record from which case now into this case?
Well, it would be a couple different, one, I guess we know, case 30808 from
Okay.
last month, but then there was the initial case where they got approved the spacing for, in Rocky Hill Field to drill those wells that are identified, on the map, the RH, I think 18H and the 116H. That's the case that we're talking about, and I don't have the case number for that.
Okay, so
offhand.
we'll incorporate the case that accomplishes what you just described.
Sure, yep.
We'll leave it open as that.
Case 29565.
29565, there you go.
Okay.
Okay, that concludes our hearing for case number 30885. Case number 30886, application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the Haystack, Butte, Round Top, Butte, Little Knife, and/or Lone Butte Bakken pools to grant relief from those portions of order number 33255 and any other applicable orders which require one horizontal well to be drilled and completed in each of two 19-20-acre spacing units described as sections 29, 20, 29, and 32, Township 148 North, Range 97 West, and Section 31, Township 148 North, Range 97 West, and Sections 6 and 7, Township 147 North, Range 97 West, prior to completing any horizontal well in the stand-up lease line 38 of 40-acre spacing unit described as Sections 31 and 32, Township 148 North, Range 97 West, and Sections 5, 6, 7, and 8, Township 147 North, Range 97 West, Dunn County, North Dakota, or granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company, LP. I'm going to have one witness in this case, Will Carlisle. I need to call them now. Hey guys, can you hear me? All right. Yep, I can hear you. We're live in the hearing room. And Mr. Examiner, with respect to 30886, before I call Mr. Carlisle, if I could just make some comments with respect to the case and the relief being sought. So Burlington Resources previously spaced the 1920 consisting of 31, 6, and 7, and then subsequent to that, got approval for the 3840 consisting of 31 and 32, and then 5, 6, 7, and 8 to drill lease line well between 31, 6, and 7 and 32, 5, and 8. And that was approved. That's the order we're talking about, order number 33255. And, you know, as is common with overlapping spacing units to allow for lease line wells, there's provisions in that order that provide that, you know, a well must be drilled in, you know, the base spacing units essentially, you know, making up that overlapping unit in order to protect relative rights. And Burlington Resources, they understand that. And with respect to one of the drilling requirements that requires development in 31, 6, and 7, and Mr. Carlisle will cover this, but that'll be covered. That won't be an issue. They'll drill on that 1920 and have, you know, multiple wells in that 1920 prior to drilling, completing that lease line well on this 3840. But then in addition to that requirement, the commission also imposed a requirement to require a well on a 1920 consisting of 20, 29, and 32. 32 is within this 3840 that we're talking about. 20 and 29 aren't. And what Burlington's looking for here is, and they understand and appreciate the requirement to protect relative rights by having development on those underlying lands. But this case is a little bit unique in that the commission is asking that a well be drilled on 20, 29, and 32, but that's an overlapping 1920 that, and there's development on all three of those sections currently. Like section 20 has a well on it, and then 29 and 32 have had development from 4 existing wells. So I guess it's Burlington's opinion that the correlative rights of the owners in 20, 29, and 32 are protected by those existing wells and that existing development that has already occurred. So it's really unnecessary to require an additional well on that overlapping 1920 consisting of 20, 29, and 32. And that's kind of the position that they have in this case, and the relief that they're seeking is, you know, from the requirement that a well be drilled on 20, 29, and 32, since those lands are already developed. And with that, I'll call Mr. Carlisle.
Wade?
Yeah,
Wade, before you proceed.
Yeah.
To make sure we're clear, 29 and 32 were developed as a stand-up 1280,
yep.
and those wells have all been plugged?
They have been plugged, but there has been development from those multiple wells on that land already.
Okay.
There isn't current production, but there has been production on those lands. They've had that opportunity
Okay.
to develop, so.
Understood.
And Mr. Garner, I'll call Will Carlisle now.
Okay. Mr. Carlisle,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do.
Will, can I have you state your name and tell us by whom you're employed and what capacity, and give us your business address?
Yes, I work for Burlington Resources as a reservoir engineer, supporting the Williston asset. Our office location is at 925 North Eldridge Parkway, Houston, Texas, at 77079. Sorry.
Okay. And Will, have you previously testified before the commission?
Yes, I have.
And have you had your qualifications received as that of an expert?
Yes, I have.
And Will, are you familiar with the development that Burlington Resources is proposing on this 3840?
Yes, I am.
Okay, I'd move the testimony of Mr. Carlisle be received as that of an expert.
Motion granted.
And Will, let's just start with your exhibit number 1.1. Can I have you just identify the spacing unit that we're discussing?
Yes, are you talking about for the lease line well specifically?
Correct, the 3840 first, yep.
Yeah, okay. So our plan is to develop that as a 15K lateral. It will be developed concurrently with the other wells, the 15K wells in section 31, 6, and 7. But the unit line well, the lease line well, will be comprised of section 31, 32, 5, 6, 7, and 8.
And then let's just move on to 1.2, and we can kind of continue on with your discussion on kind of what your development's going to look like. So 31, 6, and 7, that's a 1920 that Burlington Resources previously had spaced, correct?
Correct.
And you're going to be developing that 1920 sort of in conjunction with the 3840 for the lease line well, is that correct?
Yes, that is correct. As previously mentioned, there is very limited land for pad development in the area, so we are going to be developing these all at the same time from one pad.
All of the wells on that 1920 as well as the lease line well?
Yes, correct.
Okay. And then you'll complete the wells in the 1920 and then move on to the 3840 well?
Yes, that is correct.
Okay. And then, Will, you've got shaded then on this exhibit, there's an overlapping 1920, those lands aren't Burlington operated lands, correct?
Correct. Those are operated by other operators.
Right. And then, are you familiar with the development on each of those sections? Section 20, for example, is that an active well?
Yes, section 20, the single section well, is currently active and producing.
Okay. And then you may have heard Mr. Bohr, he indicated that, there are those 4 wells on 29 and 32, that 1280. Those are now P&A'd, is that correct?
That is correct. They were P&A due to landslide risks in the area, which, kind of adds to the story of how difficult it is for pad development in the area. Originally, we did have a pad location for the 10K lateral development of section 6 and 7. We had that planned from the north side of the river originally, and we had to relocate our pad to the south due to landslide risks in the area. So pad selection and locking in and identifying a secure and safe place to develop has been exceptionally challenged, which was preceded by the challenges that were observed in sections 29 and 32 when those wells were being P&A'd.
Right. Did those wells in 29 and 32 produce any oil?
Yes, combined they produced around 800,000 MBO, or 800,000 barrels of oil combined.
Okay, so those owners in those lands have received that benefit already?
Yes, they have.
Okay. And then, if that requirement were to remain in place to kind of put, I guess, another well, an additional well on that 1920, or I guess it would be the first well in the 1920, but, another well to drain 20, 29, and 32, if that requirement stayed in place, would Burlington still be able to drill that lease line well on the 3840?
No, we would not be able to, at least not for the 3840. The likely outcome would be
us having to revert back to the previous spacing order we received of a 10K lateral that comprised of sections 5, 6, 7, and 8. So we would be forced to develop this as a 10K lateral lease line well. For multiple reasons, as I mentioned, we're developing this all from one pad, so there will not be the opportunity to come back at a later date and drill the well at the 15,000-foot lateral. We also don't have other pad locations or another pad opportunity where we would be able to come back and drill that as a single well event. So we would be reverting back to drilling it as a shorter lateral than as proposed here.
So would that risk stranding some reserves?
I do believe it would, for multiple reasons. One, it would not be part of our near-term development plan, which we are planning to spud these wells in September of 2024. Secondly, I don't think it is secret that the other operator in question for Section 29 and 32, being XTO, have not had drilling development activity for the last several years. So without knowledge of when they would likely develop it, I do think that leaves that section to be potentially stranded.
Okay. And Will, you understand why the commission puts, these requirements in to kind of develop the, the underlying lands before being allowed to drill a section line well?
Yes, I do.
Okay. And is it essentially to protect the correlative rights of those owners in those sort of underlying sections?
Yes, I do believe that is the case.
In your opinion, have the correlative rights of those owners, have they been protected already by the existing development that's occurred on those lands?
Yes, I do believe so.
Okay. So then in your opinion, if the commission were to grant the relief from the requirement that a well be drilled on that 20, 29, and 32 spacing unit before you can develop your lease line well, would that prevent waste and protect correlative rights, and then also prevent the drilling of an unnecessary well?
Yes.
Okay. I have no further questions for Mr. Carlisle. I'd offer the exhibits.
The exhibits are admitted. Any questions from the staff?
William or Wade,
Yep.
if the lease line well is drilled, I assume it would hold the acreage in section 32?
Yeah.
Yes.
And Burlington doesn't know, and I guess nobody knows what XTO's plans are for developing that stand-up 1920?
Will, I assume you don't know what XTO's plans are?
No.
Is that something that Burlington could reach out to XTO and supply us with whatever answer they get?
Yeah. Will, would you be willing to contact XTO to inquire as to what their development plans might be and be able to respond to the commission with the response that you get?
Yes, I know that our organization has reached out previously, and that they did not provide information. I was not directly the one that reached out, but I do know that our organization has solicited that feedback without a clear response at that timeline.
Okay.
Well, could they provide that?
Do you know, is there like an email correspondence that reflected that, or was that sort of verbal conversations?
Yes, it was via email.
Would you be willing to provide that to the commission?
Sure, yes, we can.
Okay.
Okay, thank you.
Wait, how long do you need to provide that email?
Will, if a week be enough to track that down so we can get that filed?
Yes, yeah, we can do that in 3 days.
Yeah.
So the record will remain open till, looks like June 5th.
Okay.
Okay, that concludes our hearing for case number 30866. Case number 30887, application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the Haystack Butte and/or Lone Butte, Bakken Pools, McKenzie, and Dunn Counties, North Dakota to 1, terminate an overlapping 2560-acre space unit described as sections 13 and 24, Township 148 North, Range 98 West, and sections 18 and 19, Township 148 North, Range 97 West. 2, establish 2 overlapping 38 40-acre space units consisting of sections 1, 12, and 13, Township 148 North, Range 98 West, and sections 6, 7, and 18, Township 148 North, Range 97 West, and sections 24, 25, and 36, Township 148 North, Range 98 West, and sections 19, 30, and 31, Township 148 North, Range 97 West, and authorize 1 horizontal well to be drilled on each such unit, and 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing on behalf of Burlington Resources Oil and Gas Company, LP. I'll have 3 witnesses in this case: Ashley Hansen, Brenton Chetnick, and Gabrielle Jacoby.
Are they online?
Yeah, they should be.
Yes, we're here.
Ms. Hanson,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, sir.
Ashley, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, my name is Ashley Hansen. I am a staff land negotiator for Burlington Resources Oil and Gas Company, LP. I am a land negotiator in our Bakken asset, and I'm located at 925 North Eldridge Parkway, Houston, Texas, 77079.
And Ashley, have you previously testified before this commission?
Yes, I have.
Have you had your qualifications received as that of an expert?
Yes, I have.
Okay, and are you familiar with the land matters associated with the proposed spacing units?
Yes, I am.
Okay, let's go ahead and start with your exhibit 1.1. Can you identify the first proposed spacing unit?
Yes. The first locator map is what we consider our northern unit line wall for our Haystack Butte unit. The lands encompass sections 1, 12, and 13, Township 148-98, and sections 6, 7, and 18, Township 148-97. And this straddles the line between McKenzie and Dunn County. The second locator map, which is considered our southern unit line well for our Haystack Butte unit, it encompasses sections 24, 25, and 36 of Township 148-98, and sections 19, 30, and 31 of 148-97, also straddling the McKenzie and Dunn County line.
Okay. And Ashley, currently there's a 2560 consisting of 13, 24, 18, and 19 that's undeveloped, that's inconsistent with your development plans. You're seeking to terminate that, correct?
Yes, that is correct.
Okay. Let's move on then to Exhibit 1.2, if you could take us through your working interest in the proposed spacing units.
Yes, so the first table is the proposed spacing ownership for the northern unit line well, which was the encompassing of sections 1, 12, 13, 6, 7, and 18. The working interest is Burlington Resources with 54.81%, XTO Holdings with 19.23%, Grayson Mill Bakken with 11.8%, Continental Resources with 9.57%, Northern Oil and Gas with 1.43%, and other, meaning that the combined this was a category of combined owners with less than 1% working interest. That equates to 3.15%. The chart on the bottom is for the proposed spacing unit for our southern unit line well, encompassing sections 24, 25, 36, 19, 30, and 31. The working interest is as follows. Burlington Resources, 50.34%, XTO Holdings, 23.41%, Grayson Mill Bakken, 15.01%, Interplus Resources, USA Corp., 2.94%, Top Rocky Mountain, 1.74%, Northern Oil and Gas, 1.57%, and our other category of 5%.
Okay. And then let's move on to working interest in the underlying spacing units, or I guess in this case also the Haystack Butte Bakken unit.
Yes. So the next few ownership tables will be the contributing spacing units. Our first one is the Haystack Butte Bakken Pool unit. Burlington Resources is the operator, and we have 88.52%. The remaining owners equate to 11.48%. And then the next page is the Clarence Federal DSU. The operator is XTO Energy. This is encompassing 148.97, Section 6 and 7. XTO Holdings has 51.93% working interest. Burlington Resources has 18.96%, and the remaining owners equate to 29.11%. Moving on to the next spacing unit is the Arcadia DSU. This is operated by Grayson Mill Operating. It encompasses 148.97, Section 18. The working interest is Grayson Mill Bakken with 58.49%, and both Burlington Resources and Continental Resources each with 20.75%. When you flip to the next page, we have the Ernest Federal DSU. This is operated by XTO Energy. It encompasses Township 148.97, Sections 19 and 30. XTO Holdings has 63.95% working interest, and the remaining partners, including Burlington, has 36.05%. And moving on to the last contributing spacing unit is the Tilton DSU, Burlington Resources being the operator. It is encompassing 148.97, Section 31, and 147.97, Section 6 and 7. Burlington Resources has 32.78%, while the remaining partners have an interest combined of 67.22%.
And Ashley, we communicate with those other operators with respect to operatorship of these proposed section line wells?
Yes. On May 17th, email notification was sent to both XTO Energy and XTO Energy as the operator of the Clarence Federal DSU, and also the Ernest Federal DSU. And then I also sent email correspondence to Grayson Mill Energy as they operate the adjoining Arcadia DSU.
I have no further questions for Ms. Hanson. I'd offer the land exhibits.
Exhibits are admitted. Any questions from the staff?
Ashley, it's my understanding that sections 1 and 12, 148.98, and 6 and 7, 148.97 are also a lease line 2560. That wasn't mentioned in your request for termination, but I assume you would want that space unit terminated also?
Yes. Can you restate those?
Sections 1 and 12, 148.98, and section 6 and 7, 148.97.
Yes, we would want that spacing to be dismissed as well, as that would be not developed on a 15K basis, which the current application intends to do so.
Okay, thank you.
Mr. Chitnick,
Yes, hello.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Brenton, can I have you state your name, tell us by whom you're employed and what capacity, and give us your business address?
Yes, Brenton Chetnick, employed by Burlington Resources. Business address is 925 North Eldridge Parkway, Houston, Texas, 77079, and I'm a geologist on the Bakken development team.
Brenton, have you previously testified before the commission?
I have, yes.
Have you had your qualifications received as that of an expert?
Yes.
Are you familiar with the geology underlying the proposed spacing units?
Yes, I am.
Okay, I'd move the testimony of Mr. Chetnick be received as that of an expert.
Motion granted.
And Brenton, let's start with Exhibit 2.1, if you can describe the structure for us.
Yeah, so what you're looking at is a structure map on the top of the Upper Bakken Shale, and you can see we're located at the southwest portion of the Nesson Anticline, relatively simple structure. You can see a type log indicator for the next exhibit just west of the proposed 3840s. And you can also see the overlapping 3840 spacing units highlighted and the outline of our haystack view unit.
Okay. Let's move on to Exhibit 2.2 and take a look at that type log.
Yep, so this is a type log running through the lodgepole down through the upper portion of the bird bear. You can see the various stratigraphic markers that I've highlighted 50 foot above the Upper Bakken Shale, Carrington, Scallion, Upper Bakken Shale, and the main reservoir units, the Middle Bakken, and the Pronghorn units, and the Upper Three Forks and Middle Three Forks stratigraphic markers. And going from left to right, you're looking at gamma ray caliper, shallow and deep resistivity, bulk density, and neutron density, and then just some raster images of the same logs on the right-hand side there.
Okay. Let's move on then to 2.3, and if you could walk us through how you would propose to develop the spacing units.
Yeah, so the base map is showing all the existing horizontal wells and wellheads for existing wells in the area. You can see the haystack view unit shown in a green outline, and then the proposed 3840 unit line well spacing units that's dash red, and I've highlighted the two 15K wells that we plan on drilling, one to the north, one to the south, as a black dash line with a kind of a yellow halo there.
Don't have any further questions. I would offer the geology exhibits.
Exhibits are admitted. Any questions from the staff?
Excuse me, on your exhibit 2.3, the laterals you're proposing to drill, are you intending to target Middle Bakken with those or Upper Three Forks? What's your target?
So for the northern well, we are currently planning an Upper Three Forks well, and the southern well is planned as a Middle Bakken well.
And then as these are drilled between the boundary of the Haystack Butte and the spacing units to the east, are you intending to drill those directly down the section line, or will they be offset at all?
That our current plan is to put those wells right on the section line. As we work up detailed well plans and work around the existing development, we may have to shift that to comply with anti-collision and other wellbore trajectory issues that we may encounter, but our intent is to drill those close to the section line as we can.
Okay, and then I guess this might be a question for Ashley probably, but the unit agreement, does that allow for border agreements on the unit boundary?
Yes, we had to go to subsequent hearing as we're doing today in order to develop the unit line well corridor.
Okay, thank you.
Could you expand? I don't know if I understood your answer, Ashley.
So the unit operating agreement does not, allow us to develop the unit line well without further, I guess, approval from the commission for a spacing unit that encompasses land, outside of the Haystack Butte unit, in conjunction with the land inside the Haystack Butte unit.
So
We can,
The
Mark, we
commit-
can take a look at the unit agreement, and unit operating agreement, and if, to the extent that, there's anything else that needs to be done prior to development, we can follow up on that, but I think for today, we can still get this spaced, and to the extent there are any issues, relating to the unit and any obligations or requirements under the unit agreement or operating agreement, then we'll follow up.
because the commission would obviously set the space units, and whether Burlington needs to enter into a border agreement, that's outside our purview?
I mean, you've already approved the unit agreement and operating agreement. I guess I haven't reviewed those. Ashley may have, but, to determine if anything needs to be, amended or anything with that, I don't know.
Okay, but you'll do an analysis and let us know.
Sure, yep.
And Brenton, these 2 wells you plan on drilling, are you gonna drill them from a common pad near the, where they meet?
The pad will be a little bit to the southwest of the east-west kind of section lines there, but we have a series of pads that we have planned and staked that we're developing the entire Haystack Butte unit along. So these 2 wells will share a common pad.
Okay, thank you.
Ms. Jacoby? Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, sir.
Gabrielle, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Yes, my name is Gabrielle Jacoby. I am employed by Burlington Resources as a reservoir engineer for the Williston asset, and my office address is 925 North Eldridge Parkway, Houston, Texas, 77079.
And Gabrielle, have you previously testified before the commission?
I have not.
Can I have you just briefly take us through your educational background and relevant work experience?
Yes. I graduated from the University of Texas at Austin with a degree in petroleum engineering in 2021, and I've been working at Burlington Resources for 3 years on Eagle Ford and Bakken assets as a reservoir engineer.
And are you familiar with the engineering matters that are associated with these proposed spacing units?
Yes.
Okay. I'd move the testimony of Ms. Jacoby be received as that of an expert.
Motion grant.
And Gabby, let's start with exhibit number 3.1, the wellbore schematic. Can you describe for us how you would propose to drill and complete the wells?
Yes. 3.1 is a wellbore schematic of a 3-string design, starting with the 9 5/8 service casing, followed by the 7-inch production casing, and then a 4.5 cemented liner with approximately 75 stages for completion, as this is proposed as a 15K lateral.
Okay. And it sounds like the targets maybe Upper Three Forks and Middle Bakken, but this would apply to both?
Correct.
Okay. Let's move on then to the reservoir data that you've got in exhibit number 3.2. Can you take us through that exhibit?
Yes. In Exhibit 3.2, the unit area is 3,480 acres. The average TDD is 11,250 feet. The average thickness is about 41 feet. The average porosity is 6.4%. The average oil saturation, 63%. We're planning on stimulating using slickwater and prop fractures. The oil gravity is 44 degrees API at 60 degrees Fahrenheit. The bottom hole temperature is 262 degrees Fahrenheit. The expected gas oil ratio is 1650, excuse me. The gas properties are about 0.98 gravity and 1165 MBTU per MCF. The estimated reservoir pressure is 8650 psi. The estimated formation volume factor is 1.7. The oil in place is expected to be 26.1 mmSCV, and our expected oil recovery is 767,000 stock tank barrels, which results in about 2.9% expected oil recovery.
And Gabby, sorry, I think we might have a typo on the size of the proposed spacing units we're looking at. They're 3840, correct? It looks like we have 3480. Should be 3840.
That's probably a typo.
Okay. Let's move on then to 3.3A. And I think that's the northernmost proposed 3840. Can you take us through the economics for that one?
Yes. Currently, we're expecting the well to cost about $10 million and $100,000. Our working interest is 54.8% and revenue interest at 45.1%. We're assuming a $60 barrel and $2.75 MCF realized price and an oil recovery of 767,000 barrels. This results in an investment ratio of 2.3, 13% discounted cash flow of $2,899, a payout of 2.2 years, and a rate of return of 41%.
Okay. And then 3.3B, if you can take us through the economics for the other 3840, might be some different ownership
Yes.
that changes things.
Correct. A similar cost and assumed realized price, just a different working interest of 50.3%, 42.5 revenue interest, and that results in just a slightly different investment ratio of 2.4, 13% discounted cash flow of 2,889, a 2.4 year payout, and a 43% rate of return.
Okay. Gabby, in your opinion, would establishment of these two 3840s to allow for the section line wells prevent waste and protect relative rights?
Yes.
Okay. I have no further questions that offer the engineering exhibits. And Mr. Examiner, there's been some weather events down in Texas that resulted in, we don't have the gas capture plan affidavit yet. We will get that and we can submit it. If I could ask that the record be held open until the end of the week to supply that.
Sure, we'll leave the record open for a week as before,
Okay.
till June 5th.
Okay.
The exhibits are admitted. Any questions from the staff? That concludes our hearing for case number 3088887, pardon me. Case number 30888. Application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the Elida, Bakken Pool, McKenzie County, North Dakota to 1, terminate 2 overlapping 2560-acre spacing units described as sections 28 and 33, Township 152 North, Range 97 West, and sections 4 and 9, Township 151 North, Range 97 West, and sections 16, 21, 28, and 33, Township 151 North, Range 97 West. 2, establish an overlapping 40-acre spacing unit consisting of sections 28 and 33, Township 152 North, Range 97 West, and sections 4, 9, 16, and 21, Township 151 North, Range 97 West, and authorize 16 horizontal wells to be drilled on such unit. And 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company, LP. And Mr. Examiner, Ms. Hanson and Ms. Jacoby will be testifying again, but I believe I will have a different geologist, Brian Sitek.
Okay, just a reminder, the other 2 are still under oath.
All right. Ashley, let's go ahead and start with your exhibit number 1.1. Can I have you identify the proposed spacing unit?
Yes, this is a locator map for the proposed spacing unit encompassing sections 28 and 33 of Township 15297 and sections 4, 9, 16, and 21, Township 151, Range 97. The red dashed line is indicated of the overlapping 3840 acre spacing unit with requested 16 well density. And then I have the underlying DSUs identified in different colors, blue being the Rolla DSU, orange the Stuyvesant DSU, and green the Schaefer DSU.
And Ashley, just before we move on, currently I believe there's some stand-up 2560s here that haven't been developed on that stand-up 2560 basis, and you need to terminate those because they're inconsistent with your proposed development plan. Is that correct?
Yes, that is correct.
And those would be 2833, 4, and 9, I think would be one of those stand-up 2560s, and the other ones 16, 21, 28, and 33. Is that correct?
That is correct.
All right. So you're looking to do the stand-up 3840. So same concept, just to allow for the longer laterals, correct?
That's correct. To allow for the 15,000 foot lateral development versus 10,000 foot lateral development.
Sure. Let's move on then to exhibit number 1.2. If you can take us through your working interest in the proposed spacing unit.
Yes, so the working interest breakdown, Continental Resources owns 50.06%, Burlington Resources 43.67%, XTO Holdings 5.65%, and the other category 0.62%.
Okay. And
I'm on the next page. Go ahead.
no, go ahead.
Okay, the next page will be the ownership for the contributing spacing unit, which was shown on the locator map with the different color indicators. The first DSU is the Rolla DSU. The initial or the current parent well is operated by Continental Resources, and the working interest breakdown is 50% Burlington Continental Resources. The next underlying DSU is the Stuyvesant. The single parent well is also operated by Continental Resources, and the ownership breakdown is Continental Resources with 43.96%, Burlington Resources with 42.4%, and XTO Holdings with 11.77%, and the other category 1.86%. The last contributing spacing unit is the Schaefer DSU, also with the parent well operated by Continental Resources. The working interest is Continental Resources with 56.23%, Burlington Resources with 38.59%, and XTO Holdings with 5.18%.
And Ashley, do you have an agreement with Continental with respect to development on these lands, or have you communicated with them about this development?
Yes. So Burlington, as the perceived operator under this spacing application, aligns with the operatorship terms described in Exhibit E of an unrecorded compromise and settlement agreement and release of claims dated August 31st, 2016 between Burlington and Continental Resources. In addition to that contract, I also provided email notification to the landman at Continental Resources on May 20th, as they are the operator of the underlying parent wells. The receipt was acknowledged from the email, and they did not anticipate any objections.
Okay. I have no further questions for Ms. Hanson. I'd offer the land exhibits.
Exhibits are admitted. Any questions from the staff?
So Ashley, even though Continental operates all three of the underlying 1280s, you have an agreement with them that Burlington will operate the stand-up 3840?
Yes, that is correct. And this is, sorry, I'm hearing some echoing. This is also the case in other areas throughout the basin. Just nearby this proposed spacing unit, our Nording Kellogg Ranch it's a similar situation where Continental developed and drilled the parent wells, and then Burlington has since drilled all of the infill wells. There's also some situations in the reverse where Burlington drilled the parent well in a DSU, and then Continental now operates all future infill wells and has drilled those infill wells.
Okay, thank you.
Ashley, is there a reason where you're proposing this as a stand-up 3840 instead of two stand-up 1920s?
Yes, so this area was, sorry, it's echoing again. This area was unique in that we only had, the single parent wells in the underlying DSUs, and it presented a great opportunity for us to redevelop this area on a 15,000-foot lateral basis. So that's why we're moving forward with this preferred application.
But wouldn't you still be able to drill 15,000-foot laterals on two stand-up 1920s as opposed to a larger 3840 stacked?
And Ashley, if Brian's going to cover some of this too, that's fine.
Are you talking about a communitization agreement?
No, I'm wondering why you're proposing a really long stand-up spacing unit drilling north and south, I'm assuming from the center, instead of just two individual 1920s with, in each case you're drilling 3-mile laterals.
Oh, I'm sorry. Yes, I understand your question now. So spacing is surface is very limited in this area. So we're restrained to only a few locations. We have secured a location in sections 9. There'll be two large development pads that will develop this 3840 acre unit. And within each of those two pads, the drilling event will have wells going to the north and wells going to the south per each event. This also will reduce setbacks if we have this on a 3840 acre basis and allow for more productive lateral.
You can proceed.
Okay. It's Brian Sitek is next. He hasn't testified yet.
Oh, I thought I already questioned Mr. Sitek. I'm sorry. Mr. Sitek.
Yes.
Solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief.
Yes.
Brian, can I have you state your name and then tell us by whom you're employed and what capacity, and give us your business address?
Sure. My name is Brian Sitek. I'm employed by Burlington Resources as a geologist on the Bakken development team, and our business address is 925 North Eldridge Parkway, Houston, Texas, 77079.
Brian, have you previously testified before the commission?
Yes.
Have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the geology underlying the proposed spacing unit?
I am.
I'd move the testimony of Mr. Sitek be received as that of an expert.
Motion granted.
And Brian, let's start with exhibit number 2.1. Can you describe the structure underlying the proposed spacing unit?
Yes. So, Exhibit 2.1 is a structure map mapped on the top of the Upper Bakken Shale, which is representative for the Bakken Three Forks interval in this area. I've also outlined the proposed 3840 spacing unit in red, in a red dashed line. We can see this area is just on the western limb of the Nesson Anticline, and you can see the structure in the proposed unit is really consistent. There's very little structural change across the 6 sections. So a very gentle structure area. So I've also indicated the location of the type log for the next exhibit, which is just to the west, the proposed spacing unit.
So, Brian, are you saying that the geology is essentially uniform throughout, the entirety of those 6 sections?
Yes, the geology is very uniform throughout this, the proposed.
There's no sort of faulting or any other type of anomalies that you're aware of?
No, we don't see any evidence of any faulting or other anomalies that would cause, market changes between, the different sections making up this unit.
Okay. Can you just walk us through that type log real quick?
Sure. Yeah, so what we're looking at is a gamma ray log and depth track of the Van Dyke 1, which again is just west of the proposed unit. I've indicated the different different perspective intervals, I'm showing the tops of the different members of the Bakken 3 Forks, and then have indicated where we are potentially going to target the lateral for the development of this unit. So stars next to the Middle Bakken, and at the upper part of the 3 Forks Bench 2.
Okay.
And that's consistent with our other development in the area.
Sure. Let's go ahead and move on to exhibit number 2.3 then. If you can kind of walk us through how you would develop this spacing unit.
Sure. So, so I believe we're requesting 16 wells per 3840. So, that's 8 DSU wells in each, the north half and south half of the DSU. What we're currently, like Ashley mentioned, we're currently planning on, having a pad in section 9, which is near the center of the 3840, and then drilling wells both north and south, similar to how we've done in the past on 2560 acre units. This is just an area where we saw an opportunity to develop as a 3-mile lateral. That's an economically attractive prospect for us.
Okay. And Ashley touched on a little bit, but in addition to what she addressed, would there be any like cost savings or anything like that associated with the stand-up 3840?
There would be. We'd be drilling fewer wells by developing as 3-mile laterals, and if we're able to, or if we're granted a 3840, I believe we'll be able to combine the production into a single facility, which will also add to the cost savings that we would be granted.
Okay. And then I think Ashley might have mentioned, but like with the 3840 basis, would that allow you to recover some increased reserves due to sort of elimination of setbacks?
Yes, we would, be able to, have smaller, shorter setbacks, so we would have a longer producible lateral, which would result in increased resource.
Okay. And let's see, and just for context, to the south, there's 28 and 33 there. That's a 1280. You do have a case on the admin docket for increased density to kind of fully develop 28 and 32 as well, or 33, correct?
That's correct.
Okay. Let's see. That's all the questions I have for Mr. Sitek. I'd offer the geology exhibits.
The exhibits are admitted. Any questions from the staff?
Brian, I guess apologize if you mentioned it, but the wells you plan to drill, will all of them be drilled at the same time, or effectively sequentially?
We'll likely develop it in 2 separate phases. We're planning on symmetrically developing the areas, so
we're still kind of hammering things out on schedule, but likely it'll be 2 phases, maybe, but I guess there's also some potential unit line wells in this area, so, maybe an 8 well event, 10 well event, or, some combination of those numbers. So because there would be quite a bit of production, coming from, 18 3-mile wells, that's something that we would find pretty challenging to develop all at once. Through some offtake considerations, I believe.
So, when the commission first considered setting up stand-up 2560s, we established a number of requirements, and they were laid out in order number 14496 for what would need to be considered for establishing a stand-up 2560 being developed in this kind of way. I think at a minimum, we're going to want that Burlington try to satisfy those same requirements that are laid out, as if this is approved. So I think there's a number of things that haven't been presented that would be required per that order. And again, that order applies to 2560s, but I think we would want the same kind of things addressed and established if we're going to consider approving this larger 3840 stand-up development scenario. That includes quantifying cost savings, quantifying the decrease of surface impact. I know it's been testified to, but we don't have any information other than it will do it, not to the effect it will do it. So I think it's appropriate probably to ask for a supplemental that would address those items.
Okay, yeah, that's something that I think the team can prepare and send along.
Yeah, Brian, along the lines of what Rich was asking, Order 14496 laid out specific criteria the commission has to consider when approving space units like this. So you would need to supplement the record addressing each one of those. I think in addition, we would want a more detailed development plan, such as where the surface locations are at, the timing of drilling the wells. So if you're going to drill, for instance, 4 to the north and 2 to the south, we would want to know the sequence of that drilling. As you mentioned, you planned on drilling it symmetrically, but there's nothing in the record to show us how that development's going to take place, and also the timing of that development. Is, are you going to, it's not to say that you couldn't drill 4 to the north and 2 to the south if you're going to bring another rig in a few months later and equal it out. But we need those details.
Okay, yes, we can provide a more detailed development plan for you.
The other thing, I did a cursory look, and if my numbers are correct, the northern well is a Three Forks well. I believe these are all completed about the same time frame. Has produced 288,000 barrels of oil. The middle well, I'll call it, is a Middle Bakken well. Has produced 524,000 barrels of oil. And the southern well, which I believe also is Middle Bakken, has only produced 263,000 barrels of oil. So there's quite a production discrepancy between these wells. Rich mentioned earlier, I guess without the detailed development plans, why shouldn't this development be on 2 stand-up 1920s?
Yeah, no, that's a fair question. I think from our perspective, we'll have to quantify this for you, I suppose, but the cost savings that we're anticipating from having combined facilities and the reduced setbacks would outweigh having, I guess, multiple facilities on 2 separate 1920s. So But yeah, that's something we'll have to quantify and provide.
Okay, thank you.
Brian, if for whatever reason the commission didn't see fit to approve the longer, taller 3840 here, would Burlington still drill these wells on stand-up 1920s as proposed?
We'd have to, I'd likely have to meet with the team and review the larger scale plan of development. You know, we've been kind of, I guess, playing under, you know, this circumstance, and we're pretty surface constrained, so in this area, so it would be a little bit more challenging. I guess I can't like say anything with too much certainty right now.
Okay, thank you.
Mm-hmm.
You can proceed.
All right. Gabby, let's take a look at your Exhibit 3.1, and if you could describe for us how you would intend to drill the proposed wells.
If this is an example wellbore schematic for a middle Bakken well, it would be a 4-string design with a 13 3/8 surface casing, a 9 5/8 intermediate casing, a 7-inch production casing, and a 4.5-inch cement liner with 75 completion stages as it's a proposed 15K lateral.
Okay, and let's move on to Exhibit 3.2, if you can take us through the reservoir data.
Yes. The unit area is 3840 acres. The average TVD is 11,000 feet. The average net thickness is 128 feet. The porosity is 7%. The oil saturation is 66%. The planned stimulation would be a high viscosity friction reducer based fluid with rock fractures. The oil gravity is 45 degrees API at 60 degrees Fahrenheit. The bottom hole temperature is 262 degrees Fahrenheit. The expected gas-oil ratio is 2480. The gas properties are 0.98 gravity and 1165 MBTU per MCF. The estimated reservoir pressure is 8520 psi. The formation volume factor is 1.97. The expected oil in place is 44.5 mmSTD, and the primary oil recovery would be 1,160,000 STD per well, and that would result in a 2.6 estimated oil recovery per well.
Okay, and let's move on to 3.3, if you could describe for us the economics for the proposed wells.
Yes. With the proposed 4-string design and the 15K lateral completion, the estimated well cost is about $12 million. The working interest would be 43.67% and revenue interest at 37.09%, assuming a $60 per barrel and $2.75 per MCF realized price, with 1,160 STB oil recovery. That would result in a 2.57 investment ratio, 13% discounted cash flow at 5,226,000, 4.8 payout years to pay out, and an 83% rate of return.
And Gabby, in your opinion, if the commission were to approve the stand-up 3840 to allow for this development, would that prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
Yes.
I have no further questions that offer the engineering exhibits.
The exhibits are admitted. Any questions from the staff?
Wait, I assume you have the same situation for the gas capture?
Yeah, we will submit that end of the week.
Gabrielle, on your economics, I want to make sure I understand. So you're using a gross well cost of $12 million and a gross recovery of 1.1 million barrels of oil, but then your economics below that are specific to Burlington's percentage?
Yes, using the net revenue.
Okay, thank you.
Sorry, I do have one more set of questions possibly for Brian. My apologies, I forgot to ask him on your round, but with respect to your proposal, you indicated you're going to be targeting Middle Bakken and Upper Three Forks 2. Is that correct?
Yes.
And so the wells currently drilled in the individual spacing units, are any of them Three Forks 2 targets, or are they both either Middle Bakken or Three Forks 1 targets?
The wells in the proposed unit there's 2 Middle Bakken wells, that the northernmost one looks like it's a Three Forks bench 1.
Do you have Three Forks 2 or second bench Three Forks wells in the immediate area as well?
Yeah. So I think it's our Fleetwood Phantom Ship 2560 DSU just to the northeast. It's the same targeting strategy. We have the Ivan DSU just to the southwest, similar targeting strategy, and then the DSUs just to the west, the Northern Kellogg Ranch, West Kellogg, and then Carlsbad and Mazama as well to the north, all have kind of a similar targeting strategy. So, that's kind of our development.
Okay, so
I guess in the area, yeah.
where those are being developed like that, you don't have anything drilled in the first bench of the Three Forks. You're going from Middle Bakken to Upper Three Forks 2 and nothing in the middle?
Occasionally there are some wells in the upper.
When I'm going to ask for another supplemental, I guess, when you supply the previously requested information kind of satisfying the requirements of 14496, if you could also identify wells or spacing units that were developed along these lines, specifically one that would have Middle Bakken and Upper Three Forks only, Upper Three Forks 2 only. And again, I guess in the immediate areas or as close to this as you have.
Okay.
Okay, thank you.
And Brian, as a follow-up to
No problem.
make sure there's no misunderstanding when you submit your detailed development plans, we would want the targets of those laterals noted also.
Sure.
Okay, thank you.
Wade, how long would you like to keep the record open for all that?
Brian, would 2 weeks, is that a fair amount of time to be able to put all that together to get it submitted?
Yeah, 2 weeks. Good.
June 12th, I believe?
June 12th, yeah. Okay, the record will remain open in this case until June 12th. That concludes our hearing for case number 30888. Case number 30889. Application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the Elida Bakken Pool, McKenzie County, North Dakota to 1, terminate an overlapping 5120 acre spacing unit described as sections 28, 29, 32, and 33, Township 152 North, Range 97 West, and sections 4, 5, 8, and 9, Township 151 North, Range 97 West. 2, establish an overlapping 7680 acre spacing unit consisting of sections 28, 29, 32, and 33, Township 152 North, Range 97 West, and sections 4, 5, 8, 9, 16, 17, 20, and 21, Township 151 North, Range 97 West, and authorize 2 horizontal wells be drilled on such unit. And 3, granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company, LP. And Mr. Examiner, I have the same 3 witnesses appearing in this case, and Mr. Examiner, this case, it's a companion case to the previous case, and it's essentially seeking to establish the 7680 to allow for section line wells on the western side of the proposed, like the stand-up 3840 that we just discussed. So there's going to be a lot of overlap with this case and the last case, and it might make sense if the commission so desires to incorporate the record from that previous case into this one.
Yeah, I think that makes sense, Wade, because I assume we're going to request some of the same follow-up information.
Right,
And that
right.
can all be combined into one.
Yeah, I think that would be the most efficient from the standpoint of, putting together a supplemental exhibit. It all ties together.
Correct.
Same kind of development. And again, here, we'd be seeking to terminate the existing 5120s that were for lease line development on the west side of those stand-up 2560s that were discussed in the previous case as well, so.
Okay, so the record from case number 30888 will be incorporated into the case number 30889.
And would it be more appropriate just to combine the records?
Okay, then,
Yeah, I think so.
as opposed to what I just said, we'll just combine the two cases into
Yep,
one
that makes
record.
sense.
Yep.
Yep.
Okay. And you can proceed with the witnesses.
Ashley, let's go ahead and look at your exhibit 1.1, if you can identify the proposed spacing unit we're discussing.
Yes, this is the locator map, just repeating the sections, sections 28, 29, 32, and 33 from 16297, sections 4, 5, 8, 9, 16, 17, 20, and 21 from Township 15197. The red dash is our desired spacing unit for 7,680 acres with a 2-well density. The color coding indicates each of the 6 underlying 1,280 acre spacing units. The next exhibit will go into detail on the interest ownership.
Yeah, and again, Ashley, just to confirm, what we're looking to do here is this spacing is to allow for those section line wells, I guess one to the north, one going to the south, on the western side of those 3840s we discussed in the last case, is that correct?
Correct, yes.
Go ahead and move on to the working interest, exhibit 1.2.
The proposed spacing for the 7,680 acre unit is Continental Resources with 46.43%, Burlington Resources with 41.40%, XTO Holdings with 6.66%, EIV Resources Bakken with 1.82%, and the other category 3.69%. Then we get into the ownership for the contributing underlying spacing units. The first unit, the RAWA, it comprised of Township 15297, Sections 28 and 33. The parent well operator is Continental Resources, and Burlington and Continental each have 50% working interest. The next underlying spacing unit is the Stuyvesant DSU, also operated by Continental Resources from a parent well perspective. This encompasses sections 4 and 9 of 15197. Continental Resources has 43.96%, Burlington 42.4%, XTO Holdings 11.77%, and the other category 1.86%. Flipping over to the next page, the next contributing spacing unit is the Schaefer, the parent well operated by Continental Resources. The lands encompass Section 16 and 21 of 15197. Continental Resources owns 56.23% interest, Burlington 38.59%, and XTO Holdings 5.18%. The next contributing spacing unit is the Key DSU. Burlington Resources is the operator of said unit. It encompasses Township 15197, Sections 17 and 20. Continental Resources owns 36.05%. Burlington Resources owns 33.36%, and the remaining interest 30.59%. Flipping to the next page, the Nording DSU. The majority operator is Burlington Resources Oil and Gas Company LP. This is comprised of Township 15197, all of Sections 5 and 8. Continental Resources owns 41.81%. Burlington Resources owns 37.64%. And the remaining owners comprise 20.55%. The last contributing spacing unit is the Kellogg Ranch DSU. The majority operator is Burlington Resources. This unit is comprised of Sections 29 and 32 of 15297. The working interest ownership is Continental Resources with 50.52%, Burlington Resources with 46.39%, and EIV Resources Bakken with 3.09%.
I have no further questions for Ms. Hanson after the land exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
Brian, let's go ahead and take a look at 2.1, and if you can describe the structure underlying spacing unit.
Sure. This map is the same structure map as before, mapped on the top of the Upper Monacan Shale. Only difference, I guess, is we're highlighting the larger unit for the unit line wells instead of the 3840 in the previous exhibit. So, again, pretty gentle structure in the area, and the type log is the same type log from before.
Okay. And do you have a target for the section line wells?
I'll have to review the more detailed plan, but they'll be more in spacing with the DSU wells.
Sure.
I can provide that information with the detailed development supplement.
Yep, that makes sense. And then let's go ahead and move on to Exhibit 2.3 then. The development as you currently have it, with the understanding that you will be kind of supplementing this with more detail.
Yes, yeah. So, the previous laterals that we spoke about, are shown in the gray dash line, and the two unit line wells are just highlighted with kind of a yellow halo. So, just there on the western section line. So,
Okay.
The main addition here.
Yep. I have no further questions for Mr. Sytek. Could offer the geology exhibits.
The exhibits are admitted. Any questions from the staff?
I guess, Brian, just realizing you're gonna probably supply that supplemental, but your intent would be to either target the middle Bakken or that same upper Three Forks Bench 2 target for these wells?
That's correct.
Thank you. I guess I'll ask a similar question to what I asked previously. If for whatever reason, in the previous case, I asked it along the lines, if for whatever reason the commission didn't feel this spacing unit was appropriate, could you do these lease line wells from two 3840s, one to the north and one to the south, as lease line 3840s?
Yeah. It would be a similar answer. I guess I gave the last one where we would have to look at the potential pad layout and see where we could find surface.
Okay, thank you. I guess when you develop your supplemental exhibits as requested in 30888, include these lease line wells in those exhibits.
Yeah, and Mr. Suggs, Mr. Examiner, if we could probably put it all on kind of one set of exhibits for combined cases.
Yep.
Yeah.
You can proceed.
Okay. Gabby, let's look at Exhibit 3.1, assuming the wells would likely be drilled and completed sort of in the same fashion as you previously discussed.
Correct. There would be similarly sized four-string wellbore cement.
Okay. And then again, with exhibit number 3.2, reservoir data, would that essentially be the same as the last case as well?
Okay.
Correct.
Okay. And then finally, the economics of the proposed wells, 3.3.
Yes, the only difference here, a similar well cost, but a different working interest of 41.4% and a revenue interest of 34.7%. And that will create a slightly different economic metric, 2.53 of a profit investment ratio, 4,832,000, 13% discounted cash flow, 4.8 year payout, and an 82% rate of return.
And again, Gabby, if the commission were to approve this spacing to allow for that section line development on the west side, would that prevent waste, protect correlative rights, prevent the drilling of unnecessary wells?
Yes.
I have no further questions. I'd offer the exhibits, and again, we will be submitting the gas capture plan affidavit.
Okay, the exhibits are admitted. Any questions from the staff? Okay, just to point out, this record will remain open as well till June 12th for all the supplementals.
Yep.
That concludes our hearing for case number 30889. Case number 30797. Application of Murex Petroleum Corp. for an order amending the applicable orders for the Sand Rocks and/or Pobakken pools to establish two overlapping 25-60 acre spacing units described as sections 25, 26, 35, and 36, and sections 26, 27, 34, and 35. Township 151 North, Range 100 West, Mackenzie County, North Dakota, and authorize one horizontal well to be drilled in each such unit or granting such other relief as may be appropriate. This case has been continued to the June hearings. And at this time, we will take a 1 hour break till 1 o'clock. Okay, we are back on the record. It is 1 PM. We'll resume with case number 30890, petition of Duke Royalty LLC for an order providing that Iron Oil Operating LLC is not entitled to recovery of any drilling, completion, or production costs or recovery of a risk penalty on Duke Royalty's interest in the Boxcar 1-4-16H well located in the spacing unit described as sections 4, 9, and 16, Township 148 North, Range 102 West, Mackenzie County, North Dakota, as provided in NDCC 380808, and for such other relief as may be appropriate. All interested parties, please come forward.
Ramona Garcia Furlong, Box 1213, appearing as local counsel for Duke Royalty.
Tom Throne, appearing in opposition to the petition on behalf of Iron Oil Operating LLC. My address is P.O. Box 6590 in Sheridan, Wyoming.
And Anthony Hunter, appearing for Duke Royalty. My address is 2161 North Covington Circle, Wichita, Kansas, 67212.
Okay. Who will be primary counsel that can?
I will be primarily arguing the case.
Okay, so actually, since it's your petition, you can go ahead and proceed.
Thank you, Mr. Hearing Officer. The case is relatively straightforward. Duke Royalty has not been paid on its overrides. It does not have a working interest in the unit in the caption. It needs to be paid for its interest. Iron Oil is not doing so, as the operator has that responsibility. It has not fulfilled any of the statutory or regulatory requirements in order to collect a risk penalty. And because of the nature of Duke's interest, it is not susceptible to being charged for production costs and expenses. We are going to be asking for the commission to order Iron to stop not paying. That's a slightly different thing than to ask them to start paying. But that request is firmly within the bounds of the statute. It's clearly within the commission's jurisdiction. And that relief will, I think, get us what we need to end this case or perhaps take it to whatever next steps are required. Thank you.
Okay. Mr. Throne?
Yes, Mr. Chairman. Iron Oil Operating LLC will present a case on why it believes that Duke Royalty is not entitled to the payment of its overriding royalty, and that it is justified in doing so. The overriding royalty in question was conveyed and recorded subsequent to the drilling and first production of the well, among other facts. And we have one witness, the chairman and CEO of Iron Oil Operating, that will give you his reasons on why the royalty should not be paid.
Okay, you can call your first witness.
Our first witness today, actually, before we call our witness, I do have a housekeeping matter. I would like to move the commission to take judicial notice of certain facts from order number 32353 in case number 29746 pursuant to NDCC 28-32-24, subsection 1, and the North Dakota Rule of Evidence 201. This was a case heard earlier, actually, I believe it was last year, regarding Twin Cities Technical and Iron Oil. The leases and the circumstances all bear on the facts of this case. And the entire order would be fine if you recognize that. But there are 7 particular facts that I think should be read into the record, if I may proceed.
You may.
Part of number 7 of the commission's findings, Iron Oil acquired 2 state of North Dakota Board of University and School Lands oil and gas leases consisting of the northwest quarter and the southwest quarter of section 16, parentheses, state leases, on May 4, 2021. Part of finding number 9, Iron Oil signed a state of North Dakota Board of University and School Lands oil and gas leased interest assignment for each state lease on June 11, 2021. Part of number 12, Iron Oil submitted the State of North Dakota Board of University and School Lands oil and gas lease interest assignments to the North Dakota Department of Trust Lands on or about November 23, 2021, along with a $50 fee. Finding 13. The following two statements are contained in the State of North Dakota Board of University and School Lands Oil and Gas Lease Interest Assignments. Quote, "This assignment is not effective until fully executed by the Commissioner," end quote. And, quote, "Note, assignments are not valid until approved by the Commissioner of University and School Lands," end quote. Finding 14. The Commissioner of the North Dakota Department of Trust Lands approved the subject State of North Dakota Board of University and School Lands Oil and Gas Lease Interest Assignments on February 11th, 2022. And part of Finding 22, the paying owner has the burden to prove it meets the requirements for the imposition of a risk penalty when challenged. And finally, Exhibit B of Twin City Technical's case, leases number OG-21-00030 and OG-21-00031, which are the underlying leases in support of our overrides.
Any objection, Mr. Throne?
No objection.
Okay, we will take notice of those provisions.
Thank you, Mr. Hearing Officer. And with that, I will call Mr. Tim Furlong.
Mr. Furlong, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes.
Mr. Furlong, will you give your name and address for the record, please?
My name is Tim Furlong. I'm the Vice President of Duke Royalty LLC. My address is Post Office Box 2556, Bismarck, North Dakota.
And you said your relationship with Duke Royalty is?
President.
President, thank you.
Sorry.
Have you been previously qualified as an expert testifying before the North Dakota Industrial Commission?
Yes.
And have you reviewed the facts of this case?
Yes.
I move that Mr. Furlong's testimony be accepted as that of an expert.
Motion granted.
All right. Mr. Furlong, why are you here?
I'm here because Duke Royalty has not been paid by Iron Oil who is the operator of the boxcar well.
And how do you know that they're not paying you?
Well, I haven't received any money, for number one. And number two is they told me they weren't going to pay me.
In your position as president of Duke Royalty, do you have authority over books and records kept by the company?
Yes.
All right. I'm going to turn your attention to exhibit number 1.
Excuse me, do you have copies of your exhibits?
Excuse me. I think we've got a couple of spares.
You can have that one.
There you go, sir.
Yeah.
Oh, I thought we submitted the copies previously. Is that not available to?
That I'm not aware of.
Oh. They were submitted as part of our application. I apologize. I thought the commission had access to that. Should we?
Hang tight.
She's going to go make copies.
Okay.
Oh, yeah, why don't we go off the record then, until we get that accomplished? We are back on the record, and Attorney Hunter, you may proceed.
Thank you, Mr. Hearing Officer. Mr. Furlong, I'd like to turn your attention to Exhibit 1.
Yes.
All right, and can you identify that document for me, please?
It's an assignment of overriding royalty interest.
All right, and can you turn to page 5 of Exhibit 1? And what is that?
It's an assignment of overriding royalty interest as well.
All right. Are these documents kept in the ordinary course of Duke's business?
Yes.
All right. Move to admit Exhibit 1 into the record, please.
Any objections, Mr. Thorne?
No objection.
Motion granted.
Thank you. Mr. Furlong, do these documents convey the overrides that are the subject of this hearing?
Yes.
And can you tell me the recording date of the first assignment?
Would be November 16th, 2021.
All right, and can you turn to page 5 again and tell me the recording date of the second assignment?
December 1st, 2022.
All right, thank you. Mr. Furlong, can you tell us the difference between an override and a working interest?
Working interest would be a cost-bearing interest, and an overriding royalty interest would be a non-cost-bearing interest.
What's the difference between cost-bearing and non-cost-bearing?
Cost-bearing interest, or working interest, would generally be participating interest, and you would pay your portion of the expenses and receive your portion of the revenue.
Right. And
And
doesn't,
you'd be a partner in the well, basically.
and does an overriding royalty share those same characteristics?
No.
Right. Does an overriding royalty let you enter into leases?
No.
Does it let you voluntarily pool the interests?
No.
What does an overriding royalty have the right to do?
The overriding royalty has the right to just receive the revenues on a non-cost basis of the production.
Now, I'm going to ask you kind of a long-winded question here, and I'm going to ask you to bear with me, because I'm going to be quoting from a statute. So bear with me, wait till the end, and then answer the question. Does Duke have the right to drill into and produce from a pool and to appropriate the oil or gas the person produces therefrom, either for that person or others, or for that person and others?
Can you read it again?
Sure.
Please.
I'll read the important part.
Okay.
Does Duke have the right to drill into and produce from a pool?
No.
I'll turn your attention back to Exhibit 1. The Exhibit A of the first assignment, can you flip to that? It should be on, I think, the third or fourth page.
Yes.
All right, can you tell me the underlying, those leases that the assignment came from? What kind of leases are they?
State of North Dakota leases, trust lands.
All right, and can you tell me the legal description for those leases?
The first one is Township 148 North, Range 102 West, Section 16, the Northwest.
All right, and the second lease?
Second lease is Township 148 North, Range 102 West, 16, the Southwest.
All right, and can you read me the lease numbers on that?
Yes, the one covering 16 the Northwest is OG 21 00030.
All right, and the second lease?
Second lease covering 16 the Southwest would be OG 21 00031.
And Mr. Furlong, you were here when I asked the commission to take judicial notice of prior leases in the Twin Cities matter?
Yes.
Do you recall if those are the same numbers?
Yes.
And if you will turn,
I'm sorry, which assignment are you on?
yeah, we're on the second one. If you'll turn back, I think you
Oh,
read
yep,
from
I
the
read
second
from the second
assignment.
one. Sorry about that.
We'll just go a little out of order here. If you'll flip back to the first assignment,
Okay,
and then are those leases similarly state leases?
correct.
All right, and will you read the legal descriptions off those?
The first one is Township 148 North, Range 102 West, Section 16, the Northeast Quarter. The second one is Township 148 North, Range 102 West, Section 16, the Southeast Quarter.
All right. And Mr. Furlong, has Iron Oil paid you on any of your Section 16 overrides?
No.
Does Duke own any working interests in any leases?
No.
What is Duke's business?
Duke is just an overriding royalty interest company.
Does it routinely receive assignments from working interest owners as a matter of course?
Yes.
Can you estimate for me how many overriding royalty assignments Duke's had over its life?
Duke has probably had 1,500 plus overriding royalty assignments since 2011.
So you'd call receiving oil, overriding royalties a routine part of its business?
Yes, correct.
And turn your attention to Exhibit 3, if you could.
Okay.
All right. Can you identify this document for me?
This is a letter to Solocorp at Duke Royalty from Throne Law Office.
And does that letter tell you who Throne Law Office is representing?
Yes, representing Iron Oil Operating LLC.
All right. Does the letter pertain to the status of the overrides that are the subject of this hearing?
Yes,
Is this a document that's kept in the ordinary course of business of Duke's activities?
yes.
Move to admit Exhibit 3 into evidence, please.
Any
No
objection?
objection.
Motion granted.
Thank you. Mr. Furlong, I want to take your attention and point it to the second paragraph of that letter. I'd like you to read that quietly to yourself for a minute, and then, if you would, tell the commission what that paragraph means to you.
This paragraph is referencing Solocorp's non-consent to the proposal that they'd sent to us to participate. And it refers also to the Iron Oil that's going to impose a risk penalty under 380808.
And to be clear, that's addressing Solocorp.
Correct.
All right. And to be clear, the letter is addressed to both Solocorp and Duke. Is that right?
Yes.
All right, thank you. I want to direct your attention to the last paragraph of the letter. I'd like you to read that quietly to yourself, and then tell the commission what that meant to you.
They're referencing the overriding royalty interest that was carved out of the original lease. And so it would, basically, it's created another interest, separate interest.
Okay, let's focus on those words carved out. When you hear the words carved out, can you describe what you think that meant?
It would mean that it's carved out of another interest. In this case, it was carved out from the original lease, which Solocorp owned.
All right. So when you hear carved, does it feel like it's supposed to be separated, or?
Yeah, it would be separated.
All right. Do you feel like that's how Duke's override was treated by Iron Oil?
No.
Why do you say that?
Because in the paragraph, I believe, before that, they speak of Solocorp, they use Solocorp and Duke's request for payment and not delay the non-participating owner's royalty payments undermines the correlative rights of Iron Oil, and that Iron Oil assumed the risk and cost of drilling a boxcar well when Solocorp and Duke did not. So they're tying Duke's interest to Solocorp's interest in this case.
So that's kind of the opposite of carved out, isn't it?
Correct.
All right. I'm going to turn your attention to Exhibit 4, please. Can you identify that letter for us?
This is a reproposal letter of the AFE that was issued to Solocorp
And who's that
for
from?
the drilling of the well, from Iron Oil Operating,
All right. And just to be clear, who was it addressed to?
Solocorp.
What's your relationship to Solocorp?
I'm the president of Solocorp.
Right. Is this document something that's kept in the ordinary course of Solocorp's business?
Yes,
And you have authority over its books and records?
I do.
And does this letter pertain to the status of the overrides that are the subject of this hearing?
No. Or yes, it does. Sorry.
I move to admit Exhibit 4 into the record.
Any objection?
No objection.
Motion granted.
Mr. Furlong, did Duke ever get a letter like this?
No.
Let me turn your attention to Exhibit 2.
And actually, let me go back. So this letter does not reference us, Duke here. So
Correct, but it does have a bearing on Duke's
it does have the
overrides,
bearing on the Duke's override, correct?
which is why you
Right,
changed your answer.
exactly.
Thank you. Could I turn your attention to Exhibit 2?
Okay.
All right. Can you identify this letter for us?
This is a letter from the trust lands referencing the pooling agreement.
All right. And how did you come to be aware of Exhibit 2 here?
This letter I became aware of during the Twin City case.
All right, did you follow the Twin City technical case?
I did.
All right. And did you later find a pooling order that applies to this spacing unit, sections 4, 9, and 16?
Yes.
All right, and did that pooling order come before or after the voluntary pooling agreement?
After.
And does this document pertain to the status of the overrides that are the subject of this hearing?
Ask the question again, I'm sorry.
Does this document pertain to the status of the overrides that are the subject of this hearing?
Yes.
I move to admit Exhibit 2 pursuant to NDCC 283224 subsection 1 and North Dakota Rule of Evidence number 201, judicial notice.
Any objection?
No objection.
Motion granted.
Thank you. Now, Mr. Furlong, what does this document mean to you?
Which one are you referring to?
The pooling agreement.
Okay.
What's the effect of this pooling agreement?
The pooling agreement, in fact, would consolidate all the interests within the unit.
Right. Was this imposed upon the state?
Yes.
Was it, one more time, was it imposed upon the state?
No.
And how do you know it wasn't imposed upon the state?
Because it came after the voluntary pooling.
It's, the pooling was voluntary?
Right, correct.
The title of the document?
Correct.
All right.
State voluntary pool.
Voluntarily pooled. And the order that came later, was that a voluntary order? Are those voluntary orders the ones that come after?
No.
So the state, prior to anyone being compelled to join the pool, asked to join the pool, basically.
Correct. And that's generally under the terms of the lease.
Under the terms of the lease? Can you tell us more about that?
The state leases have basically a pooling clause in it. I couldn't tell you exactly what it reads, but the state interest, when you purchase it, has a pooling clause in it. So
when you purchase the lease as the lessee, do you have the authority to pool the state interest?
no.
Do you have to ask the state to ask to be pooled?
Yes.
Mr. Furlong, how much money is at stake here today for Duke Royalty?
I'm not quite sure because I don't have any accounting, but it's produced over 200,000 barrels, so, you know, I guess bar napkin math, we would say 15 to 20,000.
All right. And you say you aren't really sure because of accounting? Tell me more about that.
We haven't received any accounting on either Solo Corp's interest or Duke's interest.
You received no information at all on any of the interests?
Correct.
All right. And Mr. Furlong, have you operated wells in the past?
Yes.
All right. In your experience as an operator, are overriding royalties good or bad for an operator?
I would say bad.
And why is that?
Because it takes away from it's a cost-free interest that you would be paying from the working interest that would reduce the amount of revenue that you're going to receive under the working interest.
So, and the revenue is where you derive your money to pay expenses, is that correct?
Correct.
And cost-free shares like landowner royalties and overriding royalties don't pay those expenses?
No, they don't.
All right. So is it fair to say that operators will do what they can to reduce the share of overrides and landowner royalties if they can?
Yes.
No further questions.
Mr. Throne?
Yes, Mr. Chairman, thank you. Mr. Furlong, let's start with Exhibit 1,
Okay.
the first assignment. And the assignor is Solo Corp.
Correct.
And you said you were president of Solo Corp,
I am.
and you signed this assignment.
I did.
The assignee is Duke Royalty LLC,
Correct.
and you're also the president of Duke Royalty LLC.
That is correct.
Do you own all the interest of Solo Corp?
Yes.
Do you own all the interest of Duke Royalty LLC? Referring to the first assignment, the date of that assignment is October 12th, 2021, right?
Correct.
Is that date after the date the first well proposal was sent to Solo Corp?
I don't recall that. I'd have to look, see the proposal.
Okay. Going to the second assignment of overriding royalty, and I believe the answers to the same questions are, you're the president and signed this assignment
That's correct.
of Solo Corp, and you're also the president and own all of Duke Royalty LLC.
That is correct.
So essentially, this is conveying a burden out of your working interest to yourself as an overriding royalty interest, isn't it?
Correct.
And you just testified that doing so inhibits or detracts from the operator's ability to collect revenue to recover expenses, correct?
I don't think I testified to that. I think I testified that it would be, the overriding royalty interest does not pay any expenses.
Didn't you say it would be a detriment to the operator to have burdens on its working interest?
I don't think I used the word detriment, but I think.
You said
is
it
a
would be
burden.
bad.
It is, yes, be bad, would not be as good, right.
So the payment of this money would be bad for Iron Oil to pay the Duke overriding royalty.
Correct.
And you conveyed this overriding royalty to another entity from Solo Corp to another entity that you owned after the first proposal was made, correct?
I still don't know the date of that first proposal, so I can't answer the question.
Okay. I have no further questions for Mr. Furlong.
Got a brief redirect, if I may? Or should I can go after the commission if they'd like to ask some questions?
No, you can go ahead.
All right. Mr. Furlong, just a quick redirect, 2 questions. What happened to that first proposal that Mr. Thorne was referring to?
The first proposal, I believe during the Twin City technical case was voided, I guess, or determined that it was not in effect.
Is that why they sent a reproposal?
I believe so.
And that reproposal is at Exhibit 4?
Yes.
Would you read the date of that reproposal?
The date was July 6, 2023.
And that date comes after all of the assignments of overriding royalty, is that correct?
That's correct.
So in your experience as a landman and a petroleum professional, once assignments are of record in the county, everyone is on constructive notice of those assignments?
Yes.
And just to be clear, those assignments were all of record as of July 2023?
Yes.
Right. One other quick question. Why are overrides good in the oil industry? What use are they?
Well, overriding royalties are many times issued as part of a compensation. Sometimes you give them to a geologist because they prepared the prospect. In our case, Duke has had this arrangement with all of its working interest companies, and it's part of my compensation. So that's basically what we use it for, and that's generally what it's used for in most cases.
So without overriding royalties, geologists and landmen might not be incentivized to work in North Dakota?
Correct.
No further questions.
Any questions from the staff?
That concludes our,
Okay, no, just say no.
okay.
I'll just tell Mr. Throne he can call his first witness. I appreciate it.
Yeah, that concludes our case in
Yeah,
chief.
okay.
I'm still thinking.
Oh, I'm sorry.
Oh,
We're still thinking.
still
Okay.
thinking, okay.
So Tim, effectively, your Solo Corp interest, well, I guess, the July 6, 2023 invitation To participate, did you participate?
No.
Is it somewhere in here? What percentage is the override?
The percentage of the override varies in this case. On the east half, I believe it was burdened to 78%, and on the west half, I believe it was burdened to an 80% net revenue interest, which would be the difference between the lease, which the state leases are 3/16 royalty, so, or 18.75. So the difference between 80 and then 78 to the 18.75, or in addition to, if you want to look at it that way.
So the override is the larger? It's the 80-some percent? Or you're,
On the boxcar well, I believe it's 80%, it's at 80% net, we took it to an 80% net revenue, so it would be the difference between 80% and 20% and 18.75%. And on the east side of the well, or east side of the interest, the east side leases, that was burdened to 78%. And that, there is another well that's in this drilling unit that's operated by Petrohum. And we did participate in that well.
You'll find the numbers in Exhibit 1 on the front of both of them. If you want to refer to them later.
So it's going to be a blended override, and it's based upon 100 net acres is what we have in the unit.
so the acres that the override covers, Solocorp is responsible for paying those drilling and completion costs?
It owns the working interest.
And you're being penalized since you went non-consent?
Yeah, and we accept that penalty. We understand that. By going non-consent on the working interest, we do understand that.
So in your application, it's titled, or the caption is titled, "Not entitled to recovery of any drilling, completion, or production costs."
From the override.
So has Duke, have you been billed?
No, but we also weren't offered a proposal to drill either, so, because it's a non-cost bearing interest. But they tied it in their letter to me to the Solocorp interest. From the letter from Mr. Throne, telling us that they weren't gonna pay it, pay Duke or Solo.
Yeah, I just want to understand, so Duke has not been billed for those costs?
No,
Thank you.
or paid. So, sorry.
Tim, you testified that the overrides were a regular practice between Solocorp and Duke.
Right.
Part of your compensation.
Correct.
How long is it usually between the acquiring of a leasehold from Solocorp to turn around and assign the override to Duke?
It's generally within a couple months.
Okay. Can you confirm for us, I guess, when Solocorp acquired the lease in question, and then when, or the leases in question, and then when the royalties were therefore assigned?
Yeah, the first leases, bear with me for just a minute. First leases were acquired in 2016. And the second group of leases, I'd have to look and see when we got our assignment from Iron Oil. They were acquired through Iron Oil. Iron Oil purchased the state leases, and there were numerous partners in the lease that were assigned the lease at a later date.
Okay. But So, when you said the 2016 date, was that referring to the royalty interest that was carved out is part of Exhibit 1? Was that lease, the leasehold that was acquired in 2016?
I'm not sure what you're asking.
So I'm asking two things. When Solocorp acquired the leasehold from which the Exhibit 1 royalty was
Yes.
carved out, and then when Solocorp acquired the leasehold from which the Exhibit 2 royalty was, or override was carved out, not royalty. So if you can give me the date that you acquired the Solocorp acquired the leasehold, and then we have the date that the overrides were carved out.
Yes, so on the first one, we missed the assignment of the override until we started reviewing this other lease. And so if you read this, it was made, we did the agreement October 12th, but my compensation should have been from earlier dates, so we made it effective as November 7th, 2018. Petro Hunt went back and did pay those royalties back to the effective date, even though the assignment was made in 2021. Because Petro Hunt understands what we were doing there, and they understand that it's regularly that we have that Duke owns these overrides on not just Solocorp, but we have other entities that hold working interest and that we participate with. And so this is pretty well known in the industry that Duke Royalty will have an interest out of these companies because that's how we assign them. And so in this one, it would have been assigned, the overriding royalty assignment was assigned November 16th of 2021, and we acquired those leases in February, or the leases were dated February 2nd, 2016.
Just to clarify, if I could, Tim, just because the lease was issued on a certain date doesn't necessarily mean that's when you got your interest on that date, unless you acquired the lease directly.
Well, that was the lease, that's the date of the lease, but in the case of the state, sometimes it's a while before you actually get a lease that you can record. They don't come that day. So sometimes it can be a week, sometimes it can be months. It just depends on what the burden is over at the state. State Land Department has to issue.
And as a reminder, I read several facts into the record findings from the Twin City technical case that showed the final approval from the state came February of 2022 for assignments that were made that were submitted in November 2021.
Right.
So there's a 3-month gap between the approval of the assignment of the leases and the submission of them. The lease itself was issued on the other half, not the Petro Hunt half, but on the other half, the lease was issued June 11th of 2021. So there was a 7 or 8 month gap between when the lease was issued and when the working interest assignment was approved. Now, at that point, Solocorp would then be free to carve out the interests. But until those are approved, there's that gap.
Approved and recorded. They have to be recorded as well.
So just because there's some time that passes doesn't necessarily mean that Solocorp was sitting on something. Also, Mr. Furlong said that they missed the east half Petro Hunt leases. But as he pointed out, it's common and routine to go ahead and just backdate those things. It's an accounting procedure more than anything else. Because it's a carve out from the working interest, just moving numbers on a spreadsheet.
And some of them do slip through the cracks. I mean, we probably have a half a dozen of them over the years that have, but generally it's done as soon as the leases are issued or within a short period of time.
Okay, thank you.
Okay, Mr. Throne, you can call your first witness.
Yeah, first witness will be Mr. J.R. Rieger, who is president of Iron Oil, and I'll pass out the exhibits.
Mr. Rieger, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, sir.
Let me give them this one and you can grab me another. And I guess those guys did.
It's too long, you guys One more is all you need?
And we just need two. Thank you.
Now, does the staff each have a set of exhibits?
I'm sorry,
Do you guys all have a set of exhibits?
I do.
You can. JR, would you please state your name and address for the staff?
My name is J.R. Rieger. My address is 2507 Montana Avenue, Billings, Montana.
And for whom do you work and in what capacity?
I work for Iron Oil Operating as the CEO.
And have you, what is your occupation in addition to being CEO? You're a landman, correct?
I'm a landman by nature, yes.
And have you previously been accepted as an expert witness in petroleum land matters?
Yes.
Would you please briefly describe your duties to the staff as CEO of Iron Oil?
My duties are in the finance department, land department, business development department. I also water the plants at Iron Oil.
And are you personally familiar with all of the matters that are subject to this hearing today?
Yes.
I would ask that Mr. Rager be accepted as an expert in petroleum land matters in addition as CEO of Iron Oil Operating.
Motion granted.
JR, as the CEO of Iron Oil, are you personally familiar with the history of the leases that we're talking about today?
Yes.
Okay, starting with Exhibit 1, would you please describe the history of the leases that we're discussing today, and also the new leases as well as the older leases?
Yes, I acquired the 2016 vintage state leases that would eventually become part of our boxcar unit in November of 2019 with the intent of drilling the boxcar well. Due to COVID and us not drilling anything in 2020, we didn't drill it. Those leases expired. I reacquired the leases in 2021, and I gave a verbal agreement with some of the other members of this group, along with Solo Corp, that I would sell half of those leases back to that group at cost.
Okay, looking at Exhibits 2A and 2B, would you please describe those two exhibits?
Would you hand me yes, please. These are the oil and gas leases that Iron Oil acquired in May of 2021.
And Exhibit 3?
This is the invoice to Solo Corp for their share of the cost of the leases we acquired. The second page of this is the Solo Corp check dated June 16th, 2021 for the amount invoiced.
And did you have any obligation to convey to Solo Corp and others interest in these new leases?
I verbally said that I would, so yes.
But it wasn't through a prior agreement, it was because you thought you should let them participate?
Yes.
Using Exhibits 4A and 4B, please explain the contents of those exhibits and the assignments to Solo Corp.
This is the state lease assignment from Iron Oil to the group here in Bismarck that we assigned 50% to. Exhibit 4B is a correction assignment of oil and gas leases. And the correction was to clean up a clerical error that was found during the Twin Cities case, and it was also used to stipulate interest previously assigned.
Would you briefly describe the history of the boxcar well that we're discussing here today?
Yes, the boxcar well, let's see, we spaced the boxcar well and got it, you know, we basically spaced the boxcar well. We sent out well proposals and we spud the boxcar well on December 1st, 2021. The initial production came on approximately August 5th, 2022. Along those times, we realized we forgot to pool the leases. We have since taken care of, or pool the unit. We took care of that a little over a year ago, I think, shortly after it was producing. And the well has just been producing since. It was the first well in that unit, and currently the only Bakken well in that unit. There are some conventional wells.
Let's talk about the boxcar well in particular. Did you deliver a well proposal to Solocorp as required to participate in this well?
Yes, we delivered the initial well proposal dated October 15th, 2021. It was signed by Tim Furlong on October 22nd, 2021.
Did Solocorp respond to that first proposal?
No.
When did Solocorp assign its first overriding royalty and ask you to refer to Exhibit 6?
They assigned it, they assigned that first assignment of overriding royalty
Turn the page.
Yeah. Well, they assigned it, they recorded it November 16th, 2021, which was 2 or, I think, 4 days, let's say 3 or 4 days before the election notice was due.
And was that assignment executed after you sent the first well proposal to Solocorp?
Yes.
So Solocorp should have been aware of the well proposal when it conveyed its overriding royalty?
Yes.
Referring to Exhibit 7, please describe the production history and the dates of drilling the well and the current production to date, and identify what Exhibit 7 is.
Exhibit 7 is just a screenshot from the NDIC page. It shows the spud date of December 1, 2021, the IP date, approximate IP date of August 5th, 2022. That is further confirmed on the bottom of the second page, showing that this well produced for 25 days in August of 2022. And it ultimately shows how much production has been produced through March of 2024.
And did Iron Oil pay all of the costs of parties who did not elect to participate?
Yes.
And would that be Solocorp?
Yes.
Want to hand to you what is Exhibit 8 and ask you to identify that, please.
This is another assignment of overriding royalty interest from Solocorp to Duke Royalty.
And this is also after the well has been spud?
Correct. This is assigned approximately 5 months after the well had started producing.
So Exhibit 8, the assignment of this overriding royalty, was conveyed from the working interest owner to the overriding royalty after the well had been drilled
Yes,
and after the well had started production.
yes,
And Solo Corp paid no share of the costs of those wells.
no.
Is Solo Corp the only party that is not elected to participate in this boxcar well?
From the group that I made the verbal agreement, yes.
Did Iron Oil re-propose this well?
Yes.
I hand to you Exhibit 9 and ask you to identify that document.
This is the reproposal as per the Twin City technical hearing that we had. We reproposed this well to Twin City Technical and Solo Corp. In this, we gave them the exact amount that the well actually costs and reproposed the well, you know, after it had been pooled and after everything, after the clerical errors had been corrected.
Okay, wasn't the second assignment, Exhibit 8, executed prior to the second well proposal?
Yes.
So why then is Iron Oil contesting the payment of the overriding royalty to Duke Royalty on the working interest owned by Solo Corp?
Because Solo Corp went non-consent in the costs and of the development of the well, it was paid by us, and after they knew about the well and 5 months after it had begun producing, they assigned themselves, well, a non-arm's length transaction to Duke Royalty, an override on the well. And an override to the non-consenting working interest owner only burdens the operator.
And have you determined with any specificity what the additional burden is to the operator if this overriding royalty that was conveyed after the well was spud and began producing has on the operator, i.e. Iron Oil?
Yes, approximately $15,300. As, you know, at the end of February, that's the number.
And that's based on the reserved overriding royalty of the difference of existing burdens in 22%.
Correct.
Is 78% NRI a low NRI for a lease in the Williston Basin?
In this part of the Williston Basin, yes.
Have you prepared a cartoon that kind of outlines all of the events surrounding this overriding royalty? And I hand that to you as Exhibit 10.
Yes.
Using Exhibit 10, would you please summarize the events surrounding this dispute and emphasize why you believe Iron Oil should not recognize Duke Royalty's override in the boxcar well?
The dates of the assignment of overrides correlate extremely closely to the dates we proposed the well. Furthermore, you know, once Iron Oil acquired these leases and then offered them to this group, 5 months later we spud the well, and it just is unreasonable to me that we would sell a lease to somebody at cost, then have them go non-consent in that well, then have them carve off an overly burdensome royalty pertaining to their leases.
And did any of the parties you conveyed these new leases to verbally indicate they intended to participate?
I only spoke with one member of the group, and he mentioned that they plan on participating. However, that's just verbal communication between one guy who didn't represent the rest of the group.
Did Twin Cities ultimately elect to participate?
They did.
And did they pay their proportionate share of the cost of drilling this well?
They did.
Walk through Exhibit 10, pointing out specifically the date the well was spud, the date the well first went on production, and then note the well proposal dates as well as the assignments of overriding royalty dates.
Okay, so, on October 18th, or I think it was October 22nd, actually, Solocorp received the Boxcar well proposal via FedEx, signed by Tim Furlong. So within 30 days of that, Solocorp assigns a 1.25% override to Duke Royalty on those leases. The Boxcar well was spud December 1.
Of what year?
2021. And initial production was August 5th, 2022.
And
we
go ahead.
had the Twin City technical hearing. We reproposed the well to Solocorp and Twin Cities. Twin Cities consented and participated. July 17th, 2023, Solocorp received the second Boxcar well, and they went non-consent again. I'm sorry to just scoot back. There were a lot of dates, and it was hard to get everything organized on this. On December 1st, 2022, Solocorp assigned a 3.25% overriding royalty to Duke Royalty on these new subject leases. That was approximately 5 months after the Boxcar well IP'd, or initial production from the Boxcar well.
I have no further questions for Mr. Rager and would tender him to questions from the staff for cross-examination.
I just need a minute to review one exhibit, and then I'll examine Mr. Rieger. One moment, please.
We'll go off the record for a couple minutes.
Okay, thank you.
We are back on the record, and Mr. Hunter, you can proceed.
Thank you, Mr. Hearing Officer. Mr. Rieger, I want to turn your attention real quick to your Exhibit 4B.
Before we go through there, I'd move for admission of the exhibits. I forgot to do that.
Any objection?
I do have one objection to Exhibit 10. As a summary, I guess, of Mr. Rieger's testimony or demonstrative, I suppose it would be okay, but as evidence of the facts itself, I'd object to it being used in a substantive manner. The testimony should reflect the actual facts and evidence, not a summation.
I will note your objection, but I'm going to admit the exhibits.
Thank you, Mr. Hearing Officer.
Yes.
All right. Turn your attention to Exhibit 4B, Mr. Rieger. Looking at the signature page on page 2 of 3, I see your signature on there. I don't see anyone else's. Did you acquire approval from the assignees of this correction?
Did I acquire, did I acquire approval from the assignees?
That was my question.
To correct this?
That was my question, yes.
I think I did acquire approval. It went through the attorney from Twin Cities. They looked at it prior to me signing this.
Did anyone from Solo Corp look at it before you signed it?
No.
Did anybody from Solo Corp look at it before you recorded it?
No.
To your knowledge, did Solo Corp agree, consent, or was otherwise notified of this?
Of the assignment or the correction
The
assignment?
correction assignment.
Other than once it hit the, I don't know.
Very well.
Yeah.
I want you, would you note for us once again the recording date of Exhibit 4B?
Yeah, recording date January 30, 2023.
January 30, 2023. And let me turn your attention then to Exhibit I believe it's Exhibit 8 of your exhibits.
8. Yes.
And correct me if I'm wrong, but this is the assignment of overriding royalty interest from Solo Corp to Duke?
Correct.
And would I be correct in stating that the recording date of this assignment was December 1st, 2022?
Yes, it says there, right there at the top.
It sure does. And would I also be correct in noting that December 1st, 2022 is prior to January 2023?
That is correct.
All right. And so you, as a landman, are aware that you have constructive notice of everything in the county records, is that correct?
Yes.
All right. And so you had constructive notice of this overriding royalty assignment as of December 1st, 2022?
I wasn't looking at the records every day, but it was, I'm assuming it was recorded.
Well, that wasn't my question. As a landman, you're aware of what constructive notice is, right?
You know, I don't use it that often. If you want to define it for me.
Sure. Constructive notice is anyone who wants an interest or wants to acquire an interest in a property or deal an interest in a property is constructively notified of other parties' interests in that property by filing and recording with the county.
Okay.
Is that a fair definition?
Yes,
All right.
I would say so.
And so my question, you had constructive notice of this assignment as of December 1st, 2022?
Correct.
Thank you. And you testified that these correction assignments were to clean up a title issue with the assignment?
A clerical error.
A clerical error? What was that clerical error?
I think there was a legal discrepancy.
All right. And at the time that you submitted that, there weren't any other title issues that you were aware of with these assignments?
I don't think so.
Was there a timing issue as far as the approval from the state?
An approval from the state for,
The assignments of the overriding royalty, I'm sorry, the assignments of the oil and gas leases?
Would you ask that again?
Sure. At the time that you made the first assignment, the state had not yet approved the oil and gas lease assignments. Is that correct?
At the time I made the first assignment?
Yes, the first assignment. Is this one correct?
You know, I don't know.
All right. Iron Oil is currently collecting non-consent penalties from Solar Corp. Is that right?
Correct.
All right. And according to your testimony, the transaction between Solar Corp and Duke is a non-arm's length transaction?
The owner, president of the companies, both companies are the same, so I think that's the definition.
And is it common practice in the industry to ignore non-arm's length transactions, say between affiliates?
You know, would you ask that again, please?
Sure. I'll even give you an example. Say, for example, Hess Bakken 2 made an assignment to Hess Operating Company. Would you call that a non-arm's length transaction?
Probably.
And would it be your practice as CEO of Iron Oil to ignore that assignment?
No, not under, you know, as long as the circumstances allow for that to, you know, be assigned.
And would you please tell us what those circumstances would be?
Creating a subsequent interest of an overriding royalty after a well has been proposed or gone non-consent.
Or a subsequently created interest. That's interesting language. I'm assuming you're taking that from a joint operating agreement?
No, I'm not.
Where were you getting that from?
A conversation I had with Tim Furlong about 6 years ago.
And at that time, did Mr. Furlong tell you that that's how things ought to be?
He says you cannot create a subsequent, he told me you can't create a subsequent interest after going non-consent.
And do you know where he got that interest? Or that phrase?
I do not.
I'd like to reserve a chance to call Mr. Furlong as a rebuttal witness after this.
Request granted.
Thank you. All right. You stated that the assignments came after production started, is that right?
Yes, I think so.
All right. And you notified Solar Corp immediately that first production had begun?
No.
Did you wait to notify Solar Corp that production had begun?
I think, no, I don't think I had to notify Solocorp that production had begun. But I think it was listed on the NDIC page, and we don't keep, most of our wells are not on confidential status when we drill and complete them.
You said most of your wells are not?
I think they started out on confidential, we just stopped doing that.
Right, so you're 100% sure that the well information was not confidential?
No, I am not.
So it very well could have been confidential at the time?
Possibly.
And it could have been confidential for a significant period of time after first production began?
I don't know how long they're confidential, but we never extend them if that even is an option.
And I believe you testified that there are $15,300 in a suspense account for Duke Royalty. Is that correct?
That would be the royalty, the amount. I didn't say suspense account.
No. So is Iron Oil holding Duke's funds in suspense?
I don't know. I am not completely familiar with the accounting side of the business.
Okay. Well, who would know if Duke's Royalty is in suspense?
Our controller and our CFO.
All right. Now, you testified that 78% was a low NRI for this basin?
No, for this area.
For this area?
Yes.
What would you consider to be a standard NRI?
I don't think there is a standard NRI.
Is 80% relatively common?
Yeah, 80% is relatively common for this area.
Is 78% unheard of in this area?
In 2021 or 2019, yeah, I mean, you wouldn't want to acquire a lease with that sort of burden on it.
How about in 2022?
I don't know if I acquired any leases in 2022.
Well, but a 78% NRI burden was more common as time went farther on,
No, probably less common.
but it's
But
not,
let me,
feel free.
I would prefer to just, get 80% NRI or better.
That's your preference, but 78% is out there.
In the basin, yeah, I'm sure it's out there somewhere.
Is 78% the lowest NRI that you've seen?
No,
What's the lowest NRI you've seen?
I've, in this basin or in other basins,
In this area?
in this area,
You're testifying that 78% is uncommon or low in this area. What's the lowest you've seen in this area?
some leases taken in when oil was at $100 a barrel and people were going crazy. I'm sure there was a lower interest. Nothing comes to mind. No specific lease comes to mind, but I'm sure it was possible.
At this time, I'd like to move to admit another finding from the Twin City technical case. Finding number 19. Iron Oil testified that assigning the overriding royalty interest after going non-consent creates an undue burden for Iron Oil by allowing leases to have a 75% net revenue interest. I'll ask you again, Mr. Rieger, is 78%
Are you looking
the
for me to
lowest?
move on your,
Oh, I'm sorry, I apologize. I should let you read.
any objection, Mr. Thrill?
I have no objection, and I think it would probably be prudent to take administrative notice of that whole order, because you'll probably do that anyway.
I don't have a problem with that. We can take administrative notice of the Twin City.
That'd be fine. I just have one more thing to read in, on particular on that, so.
Okay.
We'll just do the whole thing.
Okay.
Thank you. Yeah. So, Mr. Rieger, my question to you was, is 78% the lowest in this area?
I don't know.
We'll leave it there. On your timeline and in a great deal of your testimony, you talked about the very first well proposal. What happened to that first well proposal, Mr. Rieger?
It had to do with the Twin City case, and due to the findings of that case, we thought it was prudent to repropose that well.
And you thought it was prudent to repropose that well because the commission said you can't collect non-consent penalties without it. Is that right?
I don't remember the Twin City, the language of the Twin City.
I'll just have the
Order
commission
of
take
finding.
administrative notice, judicial notice of order, paragraph 1 and 2. Twin City Technical LLC's objection to the risk penalty is granted. Iron Oil Operating LLC may not impose a risk penalty against Twin City for risk in drilling the Boxcar 1-4-16H well, file number 37896, located in the spacing unit described as sections 4, 9, 16, Township 148 North, Range 102 West, McKenzie County, North Dakota. Finding 2, or order number 2, Iron Oil may at a later date make a good faith attempt to have Twin City join in and participate in the risk and cost of drilling the Boxcar 1-4-16H well. Mr. Rieger, you sent Solocorp a notice because without it, you couldn't collect a non-consent penalty from Solocorp.
Yes.
And the commission found that in order to be acting in good faith, you should have sent more information or cleared up the lease assignment issue before sending an invitation to participate. Is that correct?
Again, I am not 100% sure of the language.
I'll just read into the record, part of finding number 27. They are not effective nor valid until approved by the Commissioner of University and School Lands, and in order to be acting in good faith, should have sent more information or cleared up the lease assignment issue before sending the invitation to participate. So, Mr. Rieger, if you were not acting in good faith when you sent the invitation to participate the first time, were you acting in good faith in denying the payment of Duke?
I'm going to
royalty?
object to the question that asks for a conclusion that's really not anywhere to be found. We've got administrative notice of the order asking what his intent was on the first proposal on whether he had good faith or not is irrelevant.
I'm going to sustain the objection.
Very well. Mr. Rieger, are you aware of any statute or regulation that permits Iron Oil to hold Duke's funds?
I can't recall verbatim, but I am aware of where one would be.
Would you like to have your memory refreshed as to the text of the various statutes in question?
No, I can't say to it right now.
So would your answer more appropriately be, I don't know?
I don't know.
All right, no further questions.
Mr. Chairman, I have a couple of quick redirects.
Go ahead.
JR, would you get exhibits 4A and 4B out? That's the assignment and the correction assignment.
Okay.
Look on page 4A, on exhibit 4A, and look at the third page, the property description.
Okay.
What's the township?
Oh, wait.
What is the township that's described?
Township 149 North, Range 102 West.
Okay, now go to the correction assignment. And would you take a look at the third page of that assignment
Yes.
and read the township?
Township 148 North, Range 102 West.
So the correction assignment correctly described the correct township.
Correct.
And is that the reason you filed the correction assignment?
Yes.
And in fact, the first assignment didn't convey anything in these leases, did it? Because it had the wrong property description.
Correct.
So it wouldn't be necessary to obtain the consent of the assignees to correctly convey the right property, would it?
No.
Okay. No further questions.
Can I have a brief recross on that, just for a second?
Sure.
Mr. Rieger, and maybe I misheard because I was making some notes, did you testify that the first conveyance of assignments of oil and gas leases didn't convey anything?
No, I said there was a clerical error.
But later on, Mr. Throne asked you a question, you didn't need anybody's permission because the first assignment didn't convey anything. Correct me if I've misheard that.
If it's the wrong township, it's not going to be constructive notice of the correct township. You know, we're kind of getting into weeds. It's unnecessary to what we're talking about.
Okay, yeah, I'm going to cut this short. We don't need to have a conversation with you between the two attorneys.
Right, and I'll just ask one other question. So, if the first assignment was effective to transfer the interest, Iron Oil no longer has that particular interest. Is that right?
We would no longer have that particular interest in the wrong township?
Yeah?
No, we wouldn't.
Okay. So if it never had it in the wrong township, it couldn't convey it in the wrong township, right?
Correct.
So your position is the first assignment was null and void?
No, that's not.
We're getting into weeds. It's totally irrelevant. I was just trying to point out that there is a reason there is a corrective assignment made, and it's done all the time when the wrong township is in there.
I understand. He's just trying to clarify the answers to the most recent questions you posed against him. That's all.
I don't know if we have that clarity yet, but I think I'm satisfied with the answers.
Okay.
Thank you.
Any questions from the staff?
JR, does Iron Oil deal with overriding royalty interests with other companies?
I'm sorry, Commissioner, would you say that again?
Does Iron Oil deal with overriding royalty interests with other companies?
Yes.
And so is there this is probably a legal question, but is there any point in time when it's illegal, if you will, to carve out an overriding royalty interest?
I don't know about the legalities of it, but once you go non-consent, according to the statute, you are, I think it's 38-08-082, operator shall have a lien, and once there's a lien on a property, you can't carve out a royalty on something that you have a lien on.
So when was the spacing unit pooled?
Pooling order, or it was pooled. I think sometime in 2023, early 2023.
I believe it was probably June 20th of 2023. It's my information I have in front of me.
Okay. I would.
Oh, I'm mistaken. No, correct. June 20th, 23 is the date the order was signed pooling the interest.
Okay.
So when did Iron Oil start collecting the risk penalty against the interest in sections 4, 9, and 16?
I think at first production.
So can you collect the risk penalty of lands that aren't pooled?
I don't think we could, but that's something I can verify with our land department.
So your contention is that the override, it was not proper because you had placed, in effect, you had placed a lien on that interest.
In effect, yes, but also, yes, from them going non-consent.
Okay, thank you.
Mr. Hearing Officer, if I could just do a brief correction or make a point of law.
Go right ahead.
3808 sub 2 says, the owner or owners so drilling or operating shall, upon complying with the terms of section 3808-10, have a lien on the share of production. So until you comply with 3808-10, you don't have a lien on production. 3808-10 is how you go about collecting upon a lien. You may fix a lien upon the interest of the debtor and the production from the drilling unit or drilling area, as the case may be, by filing for record with the recorder of the county where property involved or any part thereof is located, an affidavit setting forth the amount due. And there's been no testimony that that has been complied with. And so there's no lien on the production until you comply with -10.
Duly noted.
Thank you.
So with that being said, and I'm trying to educate myself here, is there ever a time you cannot carve out an override? And
That's not for me to say. I'll say that in this case, it's not this time. You may get a case in front of you with different facts, but the fact of the matter is that the first invitation to participate was voided by the Twin City technical case, and everything got reset then. So even if there were mistakes, clerical errors, things needed to be cleared up, improper percentages based on assignments, all that stuff that was in the Twin City case, it was a mess. And the commission gave everybody a reset button. It got pooled properly in June 2023. Before then, it wasn't even pooled. It was voluntarily pooled, as Mr. Furlong testified, but it wasn't pooled under a commission order until middle of last year. And so all those dates and discussions are kind of irrelevant because a great big reset button got dropped at the end of the Twin City technical case. So you may get a case someday where there might be something, an egregious override, a 33% drop, a 66% NRI. That's out of bounds. But it's not this case in front of you today.
thank you.
Anything further?
I had a couple of questions for Mr. Furlong on a rebuttal.
That's
from
correct, okay. You can
testimony. Mr. Furlong, you were here when Mr. Rieger testified about your conversation 6 years ago about subsequently created interest. Is that right?
Yes, I
right.
was here.
6 years ago was 2018,
Yes,
pre-pandemic,
correct,
before the original leases on the west half expired.
correct.
Do you remember the contents of that conversation?
No, I don't remember the exact contents of that question, but I've been talking about subsequently created interest for a long time because operators have told us that we couldn't create subsequently created interest. That may be true in case you have a JOA in place, but in North Dakota, we generally don't even get offered a JOA, so there is no compliance with a JOA. Under the statutes, as I understand them, in North Dakota, there is nothing that says you can't create a subsequently created interest at any time. And it can't be penalized. There's nothing there to charge you against the working interest or any working interest owner. And it's kind of ludicrous. They try to tie Solocorp and Duke together. They're two different companies. I mean, this is pretty simple law. I am not the company is not me. I mean, that's pretty basic. And so there's two different entities. One does one thing and one does another thing.
And so, Mr. Furlong, you and I have been working together for a long time. Do you recall the first time that we talked about subsequently created interest?
It's been a while. It's been
More than 6 years ago, would you
More
say?
than 6 years ago, correct.
And has your opinion about subsequently created interest changed at all during that time?
No.
And would you have stated to anyone at any time that you thought someone could stop you, a royalty owner, from creating subsequently created interest?
No, I would state that they have tried and they've mentioned it, but I'd say you can't do it.
Mr. Chairman, to the extent it's a legal conclusion, I object. To the extent it's his opinion, I'd say it's okay.
I'm going to
But I'll
let
answer.
him proceed.
And then, Mr. Furlong, are you aware of any overriding royalty assignments out of Iron Oil operating?
Yes, they did assign some overriding royalty out of this particular well.
Okay. You don't happen to recall what that percentage was, do you?
I don't.
Okay. But they exist and they're out there?
They exist, yeah,
And you've seen them in the county records?
correct.
All right. No further questions.
Mr. Thorne?
We have no further evidence to present.
Anything further from the staff? Okay, that concludes our hearing for case number 30890. That concludes our hearings for the day.
Thank you.
Thank you, Commissioners.